Morning, everyone. This hearing is in the matter of case number CFI 009-2023 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Holman Fenwick Willen. Lead counsel is Mr. Sharaf El-Shibsi, KC. The defendant is represented by Jones Day. Lead counsel is Ms. Heather Martin and Mr. Philip Devonish. Thank you, Your Honour.
Thank you very much. Yes, Mr. Shivji, what did you have in mind for this morning as a quick outline of where you were planning to go?
I was proposing to, I had a few short introductory points. I wanted to take you to some authorities on fiduciary duties and directors' duties, in particular in relation to the diversion of business, just to answer some of my learned friends' points about whether it's possible as a matter of law to do what the defendants did. I then wanted to address you briefly on the scheme, just to pick up some of the themes that my learned friend raised, in particular on the use of confidential information. I had some points on insolvency, the complaints about property and whether the business can be property, and then some other all sorted points that my learned friend raised.
All right. Well, let's see how we go. Thank you.
I'm grateful, my lord. I'm conscious that you've obviously spent quite a bit of time pre-reading, and a number of the concepts you're very familiar with. So I won't labour the point. But if I may, I'll try and get swiftly through my material. So my lord, we started yesterday's hearing with 3 discrete points of law, and that part of the hearing looked rather familiar to lawyers appearing at strikeout hearings. But the remainder of the day did not, because we spent a considerable amount of time going through the case interweaved with the evidence. And my learned friend said to you at the outset that she was going to take our particulars of claim at their highest, assuming that they were true, but that is not then how she proceeded. She also said to you that she was not asking the court to conduct any conclusive fact-finding, but again, that doesn't explain why we spent so much time looking at the evidence.
And well, there's a difference, isn't there, between the strikeout position and the summary judgment position, where if you can show the other side's case as put has no realistic prospect of success, then you can succeed on summary judgment. Absolutely. So I understood her submissions on the facts to relate to that aspect of the application. But as I indicated at the time, as soon as we get into any serious conflict of fact, it's just outside the scope of what one can do on summary judgment either.
Yes, my lord, and indeed our understanding is that whenever we went to the evidence, that was because my learned friend was seeking to rely on a point for immediate judgment purposes, summary judgment purposes. And as your lordship noted, an application like that is extremely difficult. And by my learned friend's own admission, she said that there was no area where there was overwhelming evidence. That was the phrase that your lordship put to her. And she accepted that there was no area where there was overwhelming evidence on the points that she had raised. And so we say that that is actually just a complete answer to the immediate judgment points on the evidence. And we say that putting together essentially where we are in this application, there are 5 reasons why you can dismiss it summarily. And I'll outline those, and then, as I said, I'll take you into some of the detail. So those 5 reasons are, firstly, that the application as it was originally premised and explained to you at the directions hearing, which was whether the particulars of claim as pleaded were defective in that they did not sustain the case that was made. And that was the complaint that we all understood at the end of the directions hearing. But that is not a complaint that has been made good. And there are no areas where the defendants have identified some critical component of the claim which is missing, such as this action cannot proceed. The second point is that there are occasions where the defendants assert insufficient particulars have been given of the case, but that doesn't bear scrutiny. They fully understand what this case is about. And indeed, their understanding of this case likely explains their reaction to these proceedings. They have not asked for further information under Part 19. And in fact, they issued their own proceedings in Switzerland for a negative declaration. And of course, for those Swiss proceedings, they had no expectation that we would ever appear. And in order to get their declaration, they themselves would have had to articulate the issues to the Swiss court on which they sought a ruling. So that in itself shows that at a very early stage, they fully understood what the complaint was. And their strategy at that point was to take the issues to the Swiss court for determination. But in any event, just on the point about insufficient particulars, this is a fraud case where the defendant's dishonest conduct was carried out covertly. We do not yet have a full exposition of what they did, and they will need to give disclosure in the form befitting of a fraud case, and then we will all have a clearer idea. And that, of course, is the next stage of this litigation. So, my lord, that is my second point. And my third point is, aside from the three upfront points that my learned friend raised at the start of yesterday's hearing, all of the remaining issues that we covered turn on the facts. And there are a number of pieces to that. I'll just unpack that a moment. Firstly, despite asking the court to decide these factual issues summarily, the defendants and their officers have chosen not to file any evidence. Instead, the vehicle for their substantive evidence is their solicitor's witness statement. Now, that is something expressly prohibited by the DIFC court rules. We've stated the practice direction in our skeleton argument. But that isn't just a point about form or procedure, it's also a point about substance. How can the court summarily say that factually this case is unsustainable without any evidence from the defendants on the factual points that are disputed? My learned friend went even further than the evidence filed at a number of points during yesterday's hearing. A good example was the discussion about the use of BSAM's confidential information and the recruitment of the relationship managers. She said at one point, using her phrase, that the recruitment was done by a clean team. And that's not covered in the evidence. In fact, that rather concerned us, the idea of a clean team, because that rather reinforces the complex fraud that we think occurred. But the fact that there might be layers of different personnel on the defendant's side doing different things in order to give respectability to what was a dishonest scheme is yet a further reason why this can't be determined summarily and why it needs to go to disclosure. And just exploring the factual point a bit further, even putting aside the factual issues in dispute, there are many legal issues that will be framed by the factual context in which they arise. And there is an inherent danger in the court trying to resolve points on the hop, especially when many of these legal issues have not been considered in detail in the DIFC before. And of course, this is not the trial of a preliminary issue, although at points it has felt like that. The authorities, as your lordship will be very familiar with, explain that taking such a course is a treacherous shortcut. And the court in any event is not equipped to try and decide factual issues summarily because of the lack of disclosure. And there's good reason, we say, to think that the evidence before the court at trial will be far more comprehensive and informative. And I'll give you another example. Mr. Carton's employment contract from BJSS has been redacted, and those redactions cover his financial package, his incentivization as to how he was remunerated. And we say that that is going to be illuminating as to what his personal incentives were. And it may well explain why he was determined to prefer the interests of BJSS at all times rather than the company to which he owed a duty of loyalty. So those are the sorts of things, and those redactions apparently have been made on, I'm not entirely clear what grounds, but there's no reason to think those redactions would still exist at trial. That's exactly the sort of material lordship will need to see. So just looking at the evidence, that they are not, it's not founded in material that the court can usefully use at this point. And we say that just looking at the essentially amorphous mass of the factual issues, that is further reason to take this case to trial. There are two other points I wanted to raise for summarily dismissing this application. The fourth is the sheer volume of points and the fact that there have been a moving target. Now, my lord, in any ordinary case, I wouldn't trouble you with this submission. Your lordship would just simply expect us to get on with it. We're an experienced team, and we can obviously deal with matters of great complexity even at short notice. But the scope and scale of this application in our submission is unprecedented. There were 83 grounds of complaint, and we've listed them in the schedule to our skeleton argument, and we've done that with great granularity to show your lordship exactly where the points arose. 50 odd were raised in their original application and supporting evidence. The remainder have emerged since then. On those 83 grounds of complaint, the defendants have put in, across the parties, we've put in over 150 authorities. The authorities bundle runs to 6,000 pages. That's about 20 lever arch files. And the authorities have continued to accumulate even into the run up to this hearing. My learned friend put 3 new ones in the bundle the night before this hearing. We don't believe the bundle was even sent to us until during the course of the hearing yesterday with those new authorities. And we'd objected to those going in, and your lordship wasn't even told that there was an objection. And how we meant to follow the case and respond to it when the litigation has been conducted in this way. And the defendant's tactic with these 83 points is simply to raise as many points as possible in the hope that one of them will stick, and that your lordship might get interested in one of them and then do a deep dive into that, and that they might get a win on that point. And even if they don't get a win and they lose, that then gives them an opportunity to appeal. And an appeal will allow them to delay matters, and delay is also a win for them. So it's win-win, the 83 points. And we say there's a real unfairness in litigating in this way. And litigating in this way is not tolerated in any of the international common law courts. And we submit this court as an international court wouldn't tolerate it either. But the volume of points and the factual and legal complexity to them does rather raise a further hazard in trying to determine them on a summary basis. Even on the many points that we've seen in the very extensive authorities, your lordship has not had a full citation of the relevant evidence or indeed the relevant authorities. And we say that would be an unsound foundation to make findings that will be important for the wider DRC community. Just a final point on the moving target. I mean, the reason we had a directions hearing was to avoid a moving target. There were, as far as we could see, 29 points out of the 83, which had been abandoned by my learned friend's skeleton argument. She hasn't actually conceded those 29 formally. At the start of her submissions yesterday, there were only 2 that she said that she wasn't pursuing, and there were 3 that your lordship determined. And so that brings us down to about 78. And of those 78, I'm afraid to say from yesterday's presentation, we were none the wiser as to which were being maintained or not. There was a schedule at the back of my learned friend's skeleton argument, which I think probably anticipated this problem and sought to tie their arguments in their skeleton back to their application notice. That was at page 40 of their skeleton. And I don't want to spend time working through the references now, but that is a very unfortunate presentation of the argument set out in their skeleton. And just to take the first item, which is this full limitation defence, which they say required the whole case to be struck out. And they say that was based on their application notice at 2.1e and para 13. And maybe we'll just look at their application notice. If your lordship goes to 1779 of the bundle, it's page, sorry, that's the broken out. It's a reformatted application notice, and then page 1781. These are the two references they rely on in their skeleton for why they had raised this argument that the entire action should be struck out. And the first one appears at 1781. And this is under the heading at the top. In the respect of any alleged fraudulent breaches of duty by the individual defendants. That's the topic. So fraud breaches of duty by the individual defendants. And then if you go down under general to E, it says non-fraudulent breaches of duties, torts, or misfeasance claims are time barred. So that was the limitation argument. So it was within the context of fraud breaches of duty by the individual defendants. They were saying that non-fraudulent breaches of those duties were time barred. That was what they later called the lesser included claims. And then the only other limitation argument was on page 1785. Again, this is a lesser included point, and that's at sub 13. To the extent that the claimants plead lesser included claims, blah, 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 those are time barred. So those are the two parts of their application notice that their skeleton relies on for saying that argument that the entire action is statute barred was based on the application notice. And if your lord, you don't really need to spend time on it, but actually if one does that task for many of these other categories, you see exactly the same problem. These were not foreshadowed; they were not raised at all. And we've done our absolute best to tackle the arguments, and I don't want to spend more time on the moving target. But litigation of this nature and complexity, with the serious consequences for the parties, just cannot be conducted in this way. That brings me to my final point as to why you should summarily dismiss this application. Even if the defendants succeeded on certain points that we covered yesterday, they have been unable to identify what benefit there would be at trial to determining those matters now. There's just no way, we say, that this case would be materially curtailed if they succeeded on the smattering of points that we covered yesterday. It would still involve essentially the same inquiry, the same factual inquiry, as it would do if this case simply proceeded unscathed. So there is no benefit or saving to some dissecting of the case. But in any event, the case has been presented in such a way that one can't discern from the submissions yesterday which parts of the case would actually be excised. So that in itself would no doubt lead to further debate as to exactly what had been kicked out, what amendments there should be, and that one can imagine the satellite litigation that would emerge from that, and to no benefit at all. So we say that the court should decline to engage in the sort of abstract ruling that the defendants are asking you to make. You should have a firm eye on the fact that they are looking for something to appeal in order to cause further delay. As your lordship already found in the removal application, they are motivated by preventing this case from coming to trial. So, my lord, with those introductory points out of the way, I wanted to dive straight in now to the sort of meat of some of the case. And I wanted to start by looking at some legal duties, both on fiduciary duties and then on directives more generally. Now, we say that this case is a classic case for a breach of fiduciary duty, and certainly the authorities in England over the last 200 years have well recognised that this sort of behaviour is a breach of fiduciary duty. There are 5 aspects of the fiduciary duty that I wanted to draw to your attention, which I think answers a lot of what my learned friend said yesterday. The first point is that the fiduciary duty is a duty of loyalty to the company, and there are very strict rules about no conflict and no profit. And conflicts must be raised and then considered by the company. And anyone sitting here listening to this hearing who sits on a committee or a board will be well familiar with how conflicts work. They have to be identified. They're identified at the start of meetings. They're declared, and then the chairman of the meeting will decide how a conflict should be managed. And sometimes there are a range of measures available to a board as to how to manage a conflict, but it is not acceptable simply to sort of keep quiet and prefer some other interest without the company's express authorization. So that's the first point. The second point is that the business of a company is property, and it's property which properly belongs to the company. The third point is that the diversion of business is a classic form of breach of fiduciary duty, and the prohibition on diversion of business covers both existing business and also future opportunities which accord in the authority's maturing business opportunities. My fourth point is that a director who resigns in order to take an opportunity for himself or a competitor which was properly available to his company is acting in breach of duty, and resigning is not a release from that obligation. And the fifth point, and this is, I think, a really interesting one from the authorities, but is well established, that it's a breach of fiduciary duty to divert business or an opportunity, even if the company is not in a position to pursue the business or opportunity itself. Your Lordship will probably be very familiar with that. It really stems back to Regal Hastings and right back, but we can pick that up as we go. Now, there are many authorities on these principles, and each of them involve their own particular facts. And although analogies can be helpful sometimes, one has to be a little bit cautious about simply copying and pasting the result from one case into another. So just, my Lord, developing those authorities. I'm sorry, my Lord, I think you might be on mute.
Thank you. I mean, unless those principles are an issue, I wouldn't need to look at the authorities. As a matter of English law, they appear to me to be fairly clear propositions. But is there an issue about this, Miss Martin, about those principles?
I just believe there is an issue as to how we're defining property for the purposes of the claims where return of the property is at issue. I believe that continues to be contested.
Well, it depends what, if you simply took out return of the property, there are obvious difficulties. When you're talking about a business opportunity and contracts and so on and so forth.
Correct, but I think my apologies.
The question I'm asking is whether you're saying more than that.
We're saying that it feeds into why claims such as the claim for company property should be stricken out, because the remedy that is available, it just isn't available for something as intangible as goodwill, which in any event we maintain is not property of the company in that way. It's not a separately alienable bundle of rights in the way that property is generally thought of.
All right. Well, you've heard what's said, Mr. Shivji, so perhaps you can focus.
Yeah, I mean, it's a bit disappointing, but anyway, I will just develop this point. I mean, as I said, there are lots of authorities in the bundle. I won't take your Lordship, but to Bristol and West. I'm sure your Lordship's had to look at it on many occasions. But can I just? There's an excellent citation of what a fiduciary duty is there, which your Lordship will be very familiar with. Can I just mention to you what it says about fiduciaries acting with two different principles? I mean, the essence of it, this is in our bundle at 2640 and 2641. We don't need to turn it up, but the essence of it is that where a fiduciary is acting for two principles with potentially conflicting interests, he must act in good faith in the interest of each, and must not act with the intention of furthering the interest of one principle to the prejudice of the other. And that is a really important point when we look at my learned friend's argument about two hats, the hats that the directors were wearing for BSAME and also for BJSS. Sorry, Milo. Sorry, I think you might be on mute again.
Sorry. If the duties are irreconcilable, then I've always assumed that the answer must be that the fiduciary must resign from one of those duties, possibly both, but certainly one, and of course is unable then to utilize any information he's obtained in relation to the fiduciary duty owed to the company he's resigned from. But is there any clear law about that, as to whether they're bound to resign or not?
Well, actually we might look at Bristol and West, but I think the answer is it's got to be it is a fact sensitive question, because what is irreconcilable? It's unlikely in most cases to be fundamentally irreconcilable. I mean, as I said, probably many of us in this room sit on boards and come across conflicts of interest, and it's unlikely that I mean, I suppose it's conceivable, but in most cases there might be the occasional conflict which needs to be managed. I mean, I sat on the board for Bar Mutual for over a decade, and there the barristers, we were insurers of barristers' professional indemnity, and also occasionally barristers were either facing claims or litigating claims. And those sorts of conflicts, which when they come up are fundamental and irreconcilable, can still be managed within the context of a board. So it's probably going to be an an unusual case where there is simply such a fundamental conflict that the two can't exist together. But if you were appointed as a director of two competing businesses, then that might be an irreconcilable conflict. We don't accept here that the conflict was irreconcilable. I mean, it's this sort of pattern where you've got a business who wants to have a joint venture in another jurisdiction. It's perfectly workable. But what is irreconcilable is to wear both hats, and then to be a director of both institutions, and then to compete with each other. But can we just look at Bristol and West, actually, because there might be a little bit of assistance from 2641 on this.
Yeah, that's what I'm looking at this moment.
I'm grateful, my lord.
Yeah,
exactly. And it's that last sentence that really covers off my point. So, my lord, perhaps we can then look at just try and pick up my learned friend's point about property. It's worth looking, I think, at the quartermaster case, which appears in your bundle. Actually, sorry, I'm just going to get into another. There's two versions of it in the bundle, but there's one with the head note, which is. Let's say that. No, there isn't, unfortunately. Let me just tell you a little bit about the quartermaster case, because I mean, again, one needs to be a little bit careful about analogies, but it's a case involving two individuals called Mr. Newson and Mr. Pike, and they were directors of a company called Q UK and also a company called Affinity Limited. So there was two companies, one Q UK and the other Affinity. Both businesses operated in the alcohol industry. Affinity operated a money collection business for brewers. And Q UK operated essentially a buying business for pubs. Now, Q UK was acquired by a parent, of which Mr. Newson and Mr. Pike became directors. Affinity wasn't acquired, but it sold its goodwill of its business to Q UK and thereafter became an agent of Q UK. So what happened was essentially there were two companies. One became the company of a group. The business of the other, which wasn't actually in the group, was sold into the group, at which point that company was outside the group, was only operating as an agent. So all the businesses were effectively in the group. The group parent fell into financial difficulties and resolved to put the whole group into liquidation. And Mr. Newson and Mr. Pike then went on to run the business that had been sold into the group within their old company. And one of the arguments that they raised was this is all fine because the opportunities that were essentially available to the business could no longer be pursued by the business because it entered liquidation. And in that case, that they were found essentially to be a breach of their fiduciary duties in pursuing that business, which had been sold into the entity. Now, I want to take you to that authority just to show you some of the passages, but it's helpful to just to understand the background to it. So if we pick this up now at 8234, sorry, 1 second.
Yeah.
Sorry, my bundle is just catching up.
Paragraph 71, is it?
It is, that's right. If your logic could read 71 and 72.
Yeah.
And I just want to focus, I mean, there's numerous references there to property, but in the middle of 71, it's talking about Mr. Newson and Mr. Pike through their control of Affinity. So this is the Affinity business which had been sold into QUK, making use of the property of QUK in that they made use of the information and made use of the goodwill of QUK in making the good new arrangements with Carlsberg. And that goodwill is that's the goodwill of the business, which had been, as I said, been sold into QUK. And then similarly towards the end, in 72 at the beginning, they used the property of QUK for the advantage of Affinity. And then in the middle of 72, I would still hold Mr. Newson and Mr. Pike to be liable for the misuse of property of QUK in the form of the information belonging to the company and the goodwill of that company. And then if we go on to page paragraph 75, which is just at the bottom, sorry, is on the next page, it's at 8236.
Can you just wait a moment?
I'm so sorry, my lord.
I thought I'd read somewhere the taking on of staff as well. Is there something about that in there?
I will. Let me just remind myself of that. Yes, there was. At 8234. Sorry, we just covered that actually in 871, didn't we? So 8234.
I've lost it in 71, but I thought I'd read it there somewhere.
Yeah, so it's towards the end under G, in view of the fact that Affinity took on staff formerly employed by QUK, and those staff were in the field making contact with ultimate customers.
Yeah.
So just to develop that a little bit, that was that aspect of the business had actually always been within QUK, and they essentially appropriated post the collapse of UK. So sorry, there were two different types of businesses, but yes, it was still a competing business with QUK.
Yes.
And then, my lord, I just wanted to take you to what the punchline was at 8236. And this is in relation to the remedy, that it's common ground that if they were in breach of the fiduciary's duties, as I hold, then they are liable to account for the profits made as a result of that breach of fiduciary duty. It's also common ground that are liable to account not only for the personal profits made by them, but also for the profits made by Affinity, on the basis that they effectively diverted the profits to that company.
Yes. Yeah. No, well, I'd understood that.
Great. And when we were discussing yesterday about quantum, that is also a feature of this case, that we will have to decide in due course whether the value is ascertained by reference to the damage of the business not sold, or the benefit obtained by the defendants in appropriating this business. Now, those fiduciary duties apply equally to employees as well as directors. So the defendant's point about Mr. Carton not being a de facto director are bad. And that's obvious. Plainly, a CEO cannot divert a business any more than a director can. I don't know if your lordship had a chance to look at the QBE case, or you may have seen it in the past, which is cited in our skeleton. But that actually tackles your lordship's question a moment ago about poaching of staff as well, because the poaching of staff is a breach of fiduciary duty. Now, QB was essentially a case about employment duties, but obviously it was talking about fiduciary duties. And if your lordship turns up 8179 of that judgment, at actually 8178, paragraph 169, there's just a summary there of the duties of good faith and fidelity, which are all very uncontroversial. And then at 8179, the judgment then talks about team poaching. And I'd be grateful if your lordship could just read paragraphs 170 to 175.
Yeah.
So, I mean, that applies in particular effectively to Mr. Carton, but and that really answers my learned friend's autonomy point about the relationship managers. It's just not sort of good enough to close one's eyes and say, oh well, the relationship managers were acting autonomously. 16 of the 18 relationship managers were poached. And as I think your lordship noted yesterday, over 200 clients, I think some 239 clients served termination letters. And my learned friend had obviously looked at that question of exactly how many clients were moved over, and she declined to be pinned down on the precise number, but on any view, very substantial numbers of clients moved over. So we say this is a classic poaching type scenario that falls within QBE, and that's a classic breach of fiduciary duty. Perhaps just a couple of other points. The first is I'm grateful to my learned friend, Mr. Sampson. He found another reference on your lordship's questions about irreconcilable duties and resignation. And that was in the British Midland Tool case, a decision of Mr. Justice Hart. And that is at 3139 of the bundle, para 89. It's just an I at the bottom. A director who wishes to engage in a competing business and not disclose his intentions to the company ought, in my judgment, to resign his office as soon as his intention has been irrevocably formed and he's launched himself into the actual taking of preparatory steps. So, and of course, these my learned friend often in her submissions yesterday tried to suggest that this is what we're suggesting is sort of akin to slavery, because you have some proprietary right of your employees, and none of this does that. This is just striking a balance between the freedom of the individual to act and the requirement to act in the best interests of the company. So, my lord, just a couple of other points. I'd sort of deal with this resignation point. That I can usefully deal with that now.
Yep, sorry. Yep.
My learned friend yesterday sorry, my lord, I'm so sorry, I'm just waiting for my bundles to catch up.
No, don't worry.
So I'm so sorry. Could we just if your lordship would give me 20 seconds while I just.
Yeah, of course.
The lordship could we'll just go back to the QBE case. It's page 3282. Sorry, for some reason there are two versions of sorry, this is the quartermaster case. I'm so sorry. There are two versions of it in the bundle, but my second version doesn't seem to want to now come up. So we'll go, which is another version of another reported version of it. At 3282. And para 57. This is about whether or not the duty continues after resignation, and it says there, if your lordship could just read 57, please.
Yeah.
So, I mean, in this sort of context, what you can't do is essentially resign in order to get out of your obligations and then use the company's property, that is the company's information and opportunities, to pursue them elsewhere. And that's quite different to being an employee and deciding that actually you want to go it alone. You've seen what this business has been doing for years. You think actually that you could run your own business within the market, and you think actually this is about time that I left and set up my own business. And that obviously that latter sort of behaviour is permitted, but the former sort of behaviour and the defendant's behaviour is not. Now, my learned friend, just on one other point about corporate opportunities. My learned friend said rhetorically yesterday, what are the business opportunities of a company which is being wound down? But that rather misunderstands the point, and that the Regal Hastings point, that it doesn't matter whether or not the company can actually pursue the opportunity. It is nonetheless a breach of duty, fiduciary duty, for a director to pursue that opportunity themselves. And again, that, as I said, that actually came up in the quartermaster case, where the company was placed into liquidation. But and on one of the key contracts with the brewer Carlsberg Tetley, there was evidence that actually Carlsberg Tetley wouldn't have wanted to renew its relationships with the insolvent Greek company. But even then, it was a breach of fiduciary duties to divert that opportunity elsewhere. And just as an aside, my lord, on that, it is in the IDC and Cooley case, which we don't need to turn up. It was said there that an arresting component of this part of the law is that a director who breaches his fiduciary duty and makes a profit is liable to account for that profit, even if he had acted properly in accordance with his duties, the profit would never have been earned by the company. So it was said there, I suppose, that it's an oddity that the company gets a financial benefit from the director's breach of fiduciary duty that it would never get if its director had actually acted in accordance with his duties of loyalties. And they said that although that's an arresting point, it is irrelevant. That is nonetheless the law, that directors are held to such a strict account that they have to account in these circumstances. So, my lord, that's fiduciary duties. My learned friend spent a bit of time yesterday talking about nominee directors, and she said that because the defendants were the appointees of BJSS, that somehow is an excuse or lessens the obligations that they're under. And that's a bad point. And the decision of Mr. Justice Stanley Burnton in the Global Link case makes that very clear. That's at 3047 of the bundle. And I'll just explain the facts of that case. That was a case where one of the defendants was a bankrupt and thereby prohibited from being a director of the company. And he persuaded the defendant to accept an appointment as his nominee. And if your lordship just goes to 3047 para 2, it explains at the beginning of that paragraph the facts about the bankrupt. And then I sort of pick up the latter part of the paragraph. 50% of the shares of the company were held by his sister, presumably as his nominee, and he persuaded the third defendant to accept appointment as his nominee director. A nominee director has the same duties to his company as any other director.
Yeah, I don't really understand where this is going, Mr. Shivji. I mean, a director is a director, whether or not he's appointed by a joint venture or not.
Yes, I mean, well, I didn't understand my learned friend to accept that submission, but if that is our position as a matter of
well, I don't think she went any further than saying that a fiduciary's obligations may be restricted by a contract or may be affected by the overall circumstances, but that doesn't get rid of the fiduciary duty.
No, exactly, and certainly wouldn't assist them in this case. There was one other point that she mentioned yesterday. It's an important point, although a narrow one, which is that when she was talking about the directors acting properly, she said that their obligation was to act in the interest of the shareholders as a whole. Now that isn't technically, it's quite a subtle point. It's not technically correct.
They have to act in the
best interest of the company.
And that's why right. You get the modification of duty and the situation of insolvency.
Exactly. So the fact that each of the shareholders might have secretly been quite happy with the dissipation of BSAM's business is no answer at all.
No, absolutely. It was a point I constantly was making to Miss Martin about Mr. Whalier's involvement. It's no good blaming Mr. Whalier. It doesn't let you off the hook.
Well, I'm grateful for that, my lord. So that really covers the material I wanted to analyse on fiduciary duty and director's duty. Okay. I can hopefully deal with the scheme a bit more swiftly. There were three categories of complaint. One was lack of particularity. The second was the misuse of confidential information. And the third was economic motives. The lack of particularity I can deal with very swiftly. I've already said a few words about it already. No RFI. The proceedings in Switzerland rather give the game away that they know what this case is about. There is also actually their defence. They plead to all these allegations in incredible detail. And at 159 of the bundle, which is paragraph 2 of their defence, they say, pursuant to RDC 1727 and 1728, the defendants consider that they have sufficiently articulated their own statement of events and set out the nature of their defence in relation to all relevant issues. And in cases, we've all been there, in cases where you're pleading a defence and you don't understand the case, you start by saying claim is incoherent, can't understand the allegations. And then when you go into the detail of it, the defence will be peppered with references to complaints about allegations not being understood, not particular points not being incoherent. There isn't that in this defence.
Yes.
Instead, they plead at great length to it because they know what the case. We all know what the case is. So the idea that there's lack of particularity about the scheme is unreal. But in any event, we are given some generosity by the court because we're the victim of this scheme, and we can't yet particularise all aspects of it. And there was again this unreal part to my learned friend's submissions yesterday when she was talking about the office holders' powers, and she was complaining that we weren't able to particularise how the assets under management and salary information actually got to the recruitment team at BJSSAM. And the suggestion, I think, was that we ought to have used our information gathering powers to get that information from them. But they're a defendant to this litigation. We made inquiries of them during our investigation. They didn't actually volunteer any of this. They haven't come on the record in these proceedings. They have chosen to be silent. So this is a classic case of a defendant facing a prima facie claim of fraud, saying, but you can't particularise the full detail of exactly how I executed this fraud, and therefore you can't make a complaint against me. And that's never been the law. So, my lord, that's the lack of particularity. Just on the confidential information, just at 3 points. We say this was confidential information, but the confidentiality of it is not critical. This isn't a claim for breach of confidence. And my learned friends actually say in their skeleton at one point that we can't make out a claim, a complaint for breach of confidence. But that misunderstands the point. And in the Canadian Aero case, which was a decision of the Canadian Supreme Court, which is in the bundle at 2302, can we just have a quick look at that? It's explained there that the confidentiality of information is not a critical component to the breach of fiduciary complaint. So it says there, just in the middle, at the bottom on the left-hand side, The view taken by the trial judge and affirmed by the Court of Appeal, which quoted the same passage from the reasons of Lord Russell in Regal Hastings, tend to obscure the difference between the survival of fiduciary duty after resignation and the right to use non-confidential information acquired in the course of employment as a result of experience. I do not see that either the question of confidentiality of the information acquired by O'Malley and Zaraki in the course of their work on Canary on the Guyana project, or the question of copyright is relevant to the enforcement against them of the fiduciary duty. The fact that breach of confidence or violation of copyright may in itself afford a ground of relief does not make either one a necessary ingredient of a successful claim for breach of fiduciary duty. So the point is that, I mean, much like the quartermaster case, that the defence were exploiting the company's information and experience and its employees and relationships, and it's irrelevant whether or not that was confidential or not. That's my first point. The second point, my lord, is that I think my learned friend's submission was that there was a wholly innocent explanation to the distribution of this confidential information, and as a result, it could not sustain an inference of dishonesty. And she said to you in relation to the sharing of that information that she said there are schedules showing that these very similar or exact same information was sent in prior years right around the same time, because that's the time everyone's discussing finances and closing out the year, bonuses, salary, etc. Now that submission is not a fair characterization of the evidence. The bonus round was done in January after a year end, the company's year end in December. And the bonus information obviously looked at historical performance, the performance for the year, to decide how to reward the staff. And if we look at 1184,
Mr. Shipji, we're just straying into areas of conflict of fact. I mean, you know, as soon as we look at the question, is this information confidential or isn't it? Yeah. I've got to decide issues of fact which I can't possibly decide now.
I understand. I certainly support that view, my lord. And the point I was dealing with is that I think my learned friend's submission was that this material simply cannot sustain an allegation of fraud. And it's insofar as she was saying that, it's, I mean, the threshold.
I don't need to hear you on that.
No, I'm grateful, my lord. And then she also made finally a point to you about the access of information. She said, oh, well, the shareholders agreement meant they were entitled to this information in any event. But that's a bad point. I mean, first of all, this information wasn't being shared for the purposes of the shareholders agreement. It was being shared for the scheme. But secondly, any entitlement they had under the shareholders agreement was only to use the information for the purposes given and to preserve the confidentiality of that material. So giving it to a competitor was obviously a breach of duty. My lord, just a few points on, I think the final component was that I think she seemed to be saying that there was no motive for the defendants to do this. And of course, there was a compelling economic motive. I addressed you yesterday about the value of the business, so we don't need to revisit that. But this was a very profitable business. And if we look, I'll just show you the accounts for the year ending 2012, which were audited by EY. And they're in your bundle. We go to page 1218. And the company's profits for the year ending 2011 were $8.1 million, and the profit for the year ending December 2012 was $4.2 million. I think my learned friend said yesterday it was a couple of $1 million. But this, as I said to you yesterday, the value in this business was the relationship with these non-resident Indians. They had a set of relationship managers, some of whom were drawn from the Indian community. They had very close personal relationships. And we don't accept the narrative that the defendants advance that after the change in the credit policy of BJSS, this business was suddenly materially less valuable. yes, okay, a certain range of products was taken off the menu, but the value in this business is what fees you can earn from selling products to these clients. And if you don't service these clients properly, they go elsewhere. So the bank had a great incentive to sell them products that they could earn fees of. And frankly, they wouldn't have gone to the trouble that they did to acquire these customers and their assets under management if they didn't think this was a valuable line of business.
Yes, well, I know you're addressing the comments I made yesterday, which were made on the basis of the evidence that I had seen as to the change in credit policy. And I had taken that as meaning that the claimants had previously been advising on highly leveraged financial products of one kind or another. The bank wasn't prepared to take the risk on financing in this way. And as a result, therefore, a range of products was no longer capable of being supplied. I shouldn't say supplied, but advised about and then managed by the claimants, which was the basis upon which the shareholders had decided to part company. Now, that's the narrative that appears from the evidence I've seen so far, and my comments were based on that alone. Of course, I'm well aware there may be lots of other evidence, and in the end of the day, there'll be valuers who have to look at this to decide what the business was worth.
Yes, Milo, and exactly. And the point I'm mainly making at this stage is that there were significant financial. I rather sense with my learned friend's submissions that she was really trying to downplay the attractiveness and profitability of this business, and that we say that's unreal. It generated profits of 8 million in 2011. They plainly really wanted the business, and that's why they went to these remarkable lengths to acquire it, and without paying for it. And if the business was worthless, they could have done the whole thing legitimately and acquired it as one probably should do, for a sum of money. There would have been a transaction, it would have been handed, they could have got it for tuppence, and then they would have got it free of all these problems. So my lord, there was a very strong financial incentive to transfer, and that certainly is enough to sustain a claim in fraud. So my lord, those were my points on the scheme. I'm just going to pick up a few other points, which I hope now can deal with a bit more swiftly. The next point is on insolvency and the risks of insolvency. My learned friend spent a bit of time on the Sequana case.
Well, I don't need to hear you about that. I've had a close look at both Sequana and Hunt. I missed Mr. Justice Zaccaroli's comments about the underlying rationale and where that might lead are I find quite instructive.
Yes, we absolutely we endorse that.
He's a smart man,
He's a very smart man. So I always follow what he says. But there's also, I think there's a slight danger one gets lost thinking about insolvency in this case, and of course that was the background to the scheme. But even if the company had been wholly solvent, this still would be a breach of fiduciary duty and would give us exactly the same remedy. So it's an interesting corner of the case, but one ought not to get too bogged down with it. So my lord, I'll move on to the next point, which were the complaints about property. I've already shown you the quartermaster case, which describes the business as the company's property. There are other authorities that do the same thing, but I won't trouble your lordship.
I don't need to be. Are you going to deal at some point with the, if I can put them this way, the insolvency offences?
I am, yes, my lord. I didn't some of your lordship's questions. I didn't have too much to say about them. Shall we deal with those next? It
was only the criticisms that were made in relation to them as to whether you had adequately pleaded them.
Yes,
that was the only point I was wanting you to deal with.
So I think there were only, as we understood it, there were only. I'll come to misfeasance separately, and I know we talked about misfeasance yesterday. But just as we saw it, I think there were only two real complaints. One was that for the fraudulent trading, it was said that intent had not been pleaded, and then we ended up in this considering whether or not the intention to defraud a single creditor is still intent for the purposes of fraudulent trading. I mean, my reference submissions are just wrong in principle on that, because we have pleaded intent, and that's at 158 of our predictive claim at page 64. And the intent we have pleaded is an intention to defraud the body of creditors, not just the carafes. Does your lordship have that?
Yeah, bear with me. Yeah. Yeah.
Could we please have the bundle page reference again?
Page 64.
Thank you.
So we do actually plead out the fraudulent intent specifically there. The other point to bear in mind is that there are two ways in which a fraudulent trading claim can be brought, either by reference to an intent to defraud creditors, or where the business of the company has been conducted for any fraudulent purpose. And we rely on both, and you can see that from 153, which is at page 63.
Oh, yeah.
And then if one goes to 157, that any fraudulent purpose point is then explained.
What? Sorry, say that again.
Sorry, then at 157 we explain that it's the pursuit of the scheme which falls within the idea of any fraudulent purpose.
Yeah, got you. Yeah.
So in my submission, this is a classic fraudulent trading case, and this is a wide cause of action available to office holders. In my learned friend's skeleton argument, they seem to have got it confused with wrongful trading. And wrongful trading has a much more technical component. It's essentially trading whilst insolvent.
Yeah.
And that is not a component. That's not a necessary component of fraudulent trading. It might, in some cases, fall within fraudulent trading, but it's not necessary to show that.
Leaving aside this particular case, fraudulent trading would encompass any number of companies which were, for example, indulging in criminal activity, avoidance of tax, carousel trading, that sort of thing. Is that right?
That is right. I was involved for many years in the fallout of the Icelandic Bank Count thing in the Chesterfield and Deutsche Bank case, and that was a case where the allegation, it was a fraudulent trading case where the allegation was manipulation of the credit markets. So which is has other consequences, including the allegation was criminal consequences as well, and that was relied on as part of an unlawful means conspiracy. So but that was also brought as a fraudulent trading case. So it covers the whole wide.
That was manipulation of LIBOR for the purpose of the derivatives and so on. Is that?
It was manipulation of the credit. That was pre-LIBOR. That was manipulation of the credit market. So
yes. I remember now. Yes, yes, long time ago.
Yeah. So there are. That's right. It was a long time ago. But so this is a very broad tool available to officers.
It was all to do with the credit swaps that were going on.
That's exactly right.
And all the Icelandic banks had indulged in extraordinary swaps of one kind or another, credit default swaps and so on, without, it seemed, fully understanding what they were doing.
Yes, and in that particular case, it was being funded by the Icelandic bank was essentially betting on its own solvency through credit default swaps. So it's self-referencing. So it does cover a multitude of different things.
Yeah.
So anyway, I think that's a complete answer to my learned friend's submissions on fraudulent trading. And
let me just have a look at the points that are taken in the skeleton.
Of course, my lord.
And one of the problems with the scattergun approach that's been adopted is that some of the complaints are capable of being dealt with compositely, and others aren't. And I just want to make sure that I fully understood those which do need to be dealt with individually. Well, no, sorry.
So I think they picked this up at 84, where they say that you must allege both elements of the statutory cause of action, which we do.
Yes.
So that's a bad point. Then at 85, this is actually a wrongful trading point. They say I think it's the words in practice which rather cover the shift.
That doesn't matter. Yeah.
Okay.
Yeah, so that's per. Oh yes. Yeah, no, that's all right. All right, what about transaction in fraud of creditors?
So the complaint here seems to be that there's no transaction. I think as we understand it. There's 2 points actually. This is the first point. This is not a good point. 89 is that the defendant to a transaction fraud creditor has to be still an officer at the point that the winding up is ordered. I mean, that's a point of construction about the law, but that's a bad point. And I will just grab, sorry, my lord, I'll just grab that.
Yeah, the point is the officer at the time of the scheme being concocted and stroke or executed.
Yes, exactly, and it would also be an enormous. I mean, it would if you had to be an officer at the time of winding up, you would simply resign the day before you realised it was going into liquidation, and there would be no claim against you. So it's a terrible point. So there's that one, and then the other point is that they say that we don't rely on we don't identify essentially the transaction. So that's I think at 90.
Yes.
And that is also the same point that comes up on the transaction undervalue point. 96.
Yeah.
And that is a question of law. And there we rely on the Safe Depot case, which is a section 238 transaction undervalue case, where the court found that the disposal of a business was a transaction, and that's informative because it was just to tell you a little bit about that case. The business was transferred with for no consideration, and then there was obviously a complaint about that. So again, there's parallels with what we're looking at. So we just say that the complaints about
I've got those points.
Then
misfeasance you're going to deal with.
Actually, could I just deal with my learned friend? We sort of heard a lot from my learned friend about the return of the property, but I don't accept that we are seeking an order from the court that the business is returned to us. That isn't. That is not our case, and I think her complaint is that when one comes to look at the relief within Article 115, we have used the language repay, restore, and account for such property. And I think what her fixation is on the word restore. But we've just adopted the language of, as one does sometimes pleading, with the language of the section. But we're not suggesting that this line of business is returned back to us so that we can trade it. We are looking for the traditional remedies, which would be damages, compensation, extra compensation, or accounts of profits. And we've explained actually in our prayer what we're looking for. And if they had any uncertainty about that, they could have asked. But it was all dressed up as if we were looking for some unrealistic order for the return of the business, and we're not. So just my lords, can I just say something about misfeasance? If we look at, sorry, so if we go back to 3710, which is Article 80 of the Insolvency Law 2009. And your lordship asked me yesterday whether it was apparent from the section or another section to whom this relief applied, because my submission to you was that although this section allowed a party to seek a remedy on the back of claims brought under Articles 73 to 79, it was more than that. And I said that it would also cover claims for misfeasance and breach of duty. And what I didn't draw to your attention was actually paragraph 80B, which talks about the order that the court can make. So it's to compensate the company in respect of any misfeasance or breach of fiduciary or any other duty in relation to the company. Now that language is lifted directly from section 212 of the Insolvency Act. And we say it just does not capture any of the claims within 73 to 79, because none of those claims have as an ingredient a breach of fiduciary duty. That is not a requirement to make out any of those individual claims. And so we say, although admittedly the drafting is not brilliant in this section, we say that you can infer from that 80 is intended to be broader than simply 73 to 79. And you can also infer from that to whom the section is intended to apply, which is persons who would owe a fiduciary or other duty in relation to the company. Now, that it might just be the without being critical of the draftsperson, it does look like what someone has done is tried to take the bones of section 212 but made changes. And I just get section 212 is at 2508.
Yeah.
And the scheme of section 212 is that sub 1 and 2 essentially explain to whom the section applies. And then subsection 3 sets out what the court is empowered to do. So what substantive powers the court has. It's not just a remedy. It rolled into that is the court's ability to take action. And that subsection 3 is what then ends up in the DIFC law. But essentially, the section is silent on 1 and 2. So you have to rather draw an inference as to what Article 80 is intended to cover. And I mean, my submission, my lord, just to sort of cut to the chase on this, is that I heard what you said yesterday. We've obviously gone away to think about it. What we haven't done is there are authorities that set out the legislative history of section 212 and the various purposes it's intended to serve. My submission is that your lordship would need to look at that and have some proper argument for us before deciding whether or not Article 80 was constrained in the way that the defendants allege. And my submission is that now is not the time to do that. I mean, in any event, it wouldn't, in no way would it change the scope or nature of this trial. So your lordship has some scepticism on that point. I fully understand that. We will need to go away and think about that harder. But my submission would be that it's not appropriate. Simply exercise that from the case now. It should be left in. Your lordship's made observations about it. We will have to reflect on whether we either make our point good or whether we drop it. But making a ruling now,
we're back to plain and obvious. Yeah, is it plain and obvious or not? When one's looking at point of law, it has to be a plain and obvious point of law where one side is right, which would justify a strikeout. So yes,
and also, but I would say that, I mean, this comes back to the 83 grounds of complaints point. The problem is that your lordship just hasn't had actually a proper set of analysis on some of these more complex legal points, and it's a really unsatisfactory way. I mean, for the courts to be asked to make a decision on something like that. Your lordship could fairly say, I do want to see the central authorities on section 212 to understand its history, to see what else there is before I make a ruling on the scope of Article 80. And that's just not been put before the court. And for our part, it was difficult for us to do that because we were dealing with such a range of points. So we just say that through the way that defendants have chosen to litigate this, they are hoisted by their own petard for the number of points, which means that one can't always deep dive into everything that's raised. So, my lord, I think that covered all of the complaints about the insolvency claims.
Yeah.
There was just a few other sort of scattering of points, which I should say something about. There was a complaint that we hadn't particularized the knowledge of the fifth defendant, but that isn't, and my learned friend said that we'd only referred to Mr. Cunningham in our skeleton, but that isn't correct. We have pleaded Mr. Cunningham's knowledge, and we have alleged in our pleading that his knowledge should be attributed to the fifth defendant, and that's in sorry, I'll just get that reference. That is page 60 of the bundle. As pleaded at paragraph 47 above, Mr. Cunningham, SEO of Asset Management, had contacted BSA's clients stating that BSA and Asset Management were to be merged. It is to be inferred that Mr. Cunningham had knowledge of the scheme and that this knowledge is to be attributable to Asset Management. So we have properly pleaded the knowledge that we know about, but obviously we reserve the right to flesh that out following disclosure.
That's paragraph
140.6 on page 60.
Oh, yeah, I'd noted that. Yeah.
And then there was a point about Mr. Sassoon. They said we'd pursued a confused case against him because we have alleged that he was both in breach of his duties and also that he was a dishonest assister. But the dishonest assist, that is a sort of temporal complaint because he was a director up to a point. He then resigned, and we also want to capture his conduct post resignation if our breach of fiduciary duty claim doesn't reach him. So it is a belts and braces approach to cover all, but again, we're allowed to do that. So my lord, that covers my points. Can I just pull it together as to where we are? I mean, we say that this is a prima facie case of fraud, and that we have well established the burden on us to show that these allegations have been properly made at this stage. And we say that is a case that is crying out to go to trial. And your lordship has already found that the defendants are doing what they can to delay the progress of this case. And we say that actually on the fact of this particular case, their conduct is effectively a challenge to the integrity of this jurisdiction. It is remarkable, we say, the lengths that they've gone to avoid their conduct being scrutinised, including secretly starting proceedings elsewhere, challenging this court's jurisdiction. And I say that in particular by reference to the fifth defendant, which is a regulated DIFC entity regulated by the DFSA, which still says it doesn't accept the jurisdiction of this court. And also they've made unfounded allegations against the liquidator and his legal team. And all of those features are all designed to stop the defendant's own conduct being scrutinised. And we thought it was telling from the exchange yesterday from my learned friend that she said that when a new liquidator was appointed, they'd need time to consider this litigation. And based on the conduct of the defendants to date, one can only guess the lengths that they will then try to go to discourage the new liquidator from pursuing this case. But we say this case is a proper case. It would be a great injustice if a meritorious case like this was prevented from coming to trial because of the defendant's behaviour. It would reward dishonest behaviour, and it would reward litigating in this way. And this court has always stood up in favour of victims of fraud, and it holds litigants before this court to a very high standard. So we say this case must go to trial. And the defendants, I mean, part of the reason I've spent a bit of time also developing these points on quantum as well is because it's important to send a message to the defendant that this is a serious case, it's a serious matter that they have to respond to, and that there are serious consequences if they don't essentially deal with it properly. And I'd note just in passing that on the defendant's own cost schedules, they've spent $1.1 million on fighting this application and also the removal application. And the defence are commercial institutions. They're spending that money commercially because they think it's in their best interest to do so. But that rather gives the game away as to, in truth, how they see the seriousness of this case and the serious financial consequences of it, if we are right. And we say that money shouldn't be wasted in this way. They should spend that money and their efforts in getting this case to trial. It could come to trial very quickly. I mean, we've obviously heard what your lordship had to say about timing. For our part, we're very keen to keep your lordship involved in this matter because your lordship spent a lot of time getting to grips with the issues, and that there's going to be a significant court saving if your lordship can continue to be involved. And it would certainly benefit from having continuity in case management going to trial. But I appreciate that if your lordship is with me on strikeout, then we will have to look at respective diaries and see how best to proceed. So, my lord, those are my submissions, unless there's something else I can assist you with.
No, thank you very much. Miss Martin.
Thank you, Your Honour. On the basis that Mr. Shivji's summation was, it could be taken as an attack on the honesty of the legal team, or the behaviour, at least, of the legal team.
I don't think any suggestion of dishonesty has been made against you, and I wouldn't countenance it.
No, I wouldn't. No suggestion of integrity issues or impropriety. I would never do that. So I want to make that very clear.
Thank you very much. I do, though, think that we should draw the court's attention to a letter sent in by Mr. Berganza yesterday, which is at the hearing bundle at 8363.
Is this about the Chinese wall and its effectiveness or ineffectiveness?
It is, and
well,
while we're not,
I've read that, but it doesn't affect today's issues, does it?
Okay, it doesn't, but we consider it wholly unsatisfactory. This is information that we asked for, that they didn't bother to look into at the relevant time, that was subject to a live pleading for a period of time, and that they sent in a letter contradicting their evidence in relation to that afterwards. I would also just like to note, in response to Mr. Shivji's suggestions that we somehow snuck in cases into the bundle over their objections, we had emailed their team about 3 new authorities that were purely in response to what they had submitted in their skeleton, and we did so. We received their skeleton, I think, at 4 p.m. and we sent the email at 7:38 p.m. And their solicitors responded at 8 a.m. the next morning. Now, of course, they're entitled to take the evening off if they want to, but that's not generally the schedule that we keep when we're preparing for a hearing. So it was a more than 12 hours later asking for explanation, which we then provided. And then they actually agreed subject to their objections. So while we note that they did have objections to the cases being added, we would suggest there's nothing unorthodox in the way that we went about adding rebuttal cases to the cases that they found. Now, they also suggest that there was some problem with the fact that employment contracts were provided with redactions, but we raised that we were providing those employment contracts with the redactions, and they said that there were no further issues. And all of that can be found in a letter that was sent to HFW on 25 October 2023. I don't know if it's in the current bundle, and I don't intend to take the court to it, but I do believe that there are some unfair allegations being lodged our way about the way in which the litigation is being conducted, and we believe that there's quite an effort by HFW to make this as difficult as possible to litigate that is feeding into it. So if Mr. Shivji has difficulty with some of this back and forth, I would suggest he has a conversation with his own solicitors to perhaps encourage more cooperation. Now, as to the point that he raises, which the court, of course, raised yesterday about not having any primary evidence from particularly the individual defendants themselves, this is not a situation in which they have chosen not to file any evidence. There are just certain procedures that will need to be followed in order for the defendants to provide evidence consistent with Swiss criminal law. And at the pace we've been going at, there just simply hasn't been time. So it's not even an option that we could have considered. It is a subject that I will ask the court and Mr. Shivji to pay attention to when it comes to scheduling, because we do believe that the best route to the most fulsome disclosure is a letter rogatory from the court, and I'll explain why. This is not us attempting to be difficult, this is not us attempting to delay, but we can't participate in these proceedings in a way that puts the defendants in jeopardy of being in violation of Swiss criminal law. So it's just, those are just procedural constraints that are in effect by virtue of the multi-jurisdictional nature of this litigation, and constraints that the claimant's own Swiss law expert from Lalive agreed exist at the time that he provided his evidence. So I don't think that it's controversial that they exist. We'll just ask for the court's help in circumnavigating those at the appropriate time. And just one last note on the sort of form of pleading. Things like lesser included claims, it's a very American formulation of the points that we made. And so it's simply just a product of my sort of education and training that it came out in those words. Similarly with the way that our defense was presented, it's probably presented in a more American style. And so my apologies if that's not fully translating, but we weren't intending to do anything that obscured our true intentions and our arguments before this court. So there were really only a couple of very short substantive points that I wanted to visit. And one is on this question of property, and we would take the court to, I believe, we have 2 cases we wanted to take it to on this point, and one is the Noakes case, which was cited in our skeleton. So starting on page 2117. So the reason we draw the court's attention to this is that the facts are very similar. And so kind of going down to maybe 2/3 down on the page, maybe halfway through the second paragraph, where it says, I do not see why there should be any great practical difficulty in the old company announcing to its work people that the undertaking is about to be transferred to a new company, giving the necessary notice to terminate existing engagements and informing the wage earners that the new company is prepared to re-engage them on the same terms and that continuing service after such date will be taken as acceptance of the new offer. So we raise this just to give the context of that this is, these are allegations regarding employment agreements. And so we would ask the court to read on to page 2118. At the top where it says, I do not agree with the views expressed to the Court of Appeal that a right to the service of an employee is the property of the transferor company. Such a right cannot be the subject of gift or bequest. It cannot be bought or sold. It forms no part of the assets of the employer for the purpose of administering his estate. And if we move down to page 2147, in the last paragraph, it says, I may sum up my view by saying that the word property in section 154, whether considered alone or in conjunction with the words rights and powers of every description, means property with which the original company has the right to deal without having to obtain the consent of some third party. And of course, employees have third-party consent rights in these situations. And so we would say that the employment contracts of the RMs were not the property of BSA. If I could briefly revisit our arguments on the claims that do not exist under DIFC law. We considered overnight the court's reference to Article 11 of the trust law, and we considered that, and it came to our attention that maybe the thing to do in these circumstances is to go back to the very basics. And so, unfortunately, I think on the evidence and authorities that made it in, the definitions from the DIFC trust law did not make it into the bundle, but I just wanted to offer a couple for the court's consideration. So the definitions in Schedule 1, Section 3 of the Trust Law 2005 are: trustee means a person appointed to act as a trustee of a trust in accordance with the provisions of this law. So a trust is a right enforceable solely in equity to the beneficial enjoyment of the property to which another person holds the legal title. And in fact, it did make it in, so page 3331. So I'll let the court go there.
Can you give me the reference again?
Sure, 3331.
Oh, sorry. Yes, you're right. Yeah.
And so it was corrected that the reference that did not make it into the bundle is the definition in the English statute, which is the Trustee Act 1925. And that definition is: trust does not include the duties incident to an estate conveyed by way of mortgage, but with this exception, the expressions trust and trustee extend to implied and constructive trusts and to cases where the trustee has a beneficial interest in the trust property. It goes on, but I'll stop for those purposes because it simply goes further than the definition in the DIFC statute, in that it explicitly includes implied and constructive trusts. So when this DIFC definition of trust is fed back into the substantive provisions, it is notable that Article 58, which sets out liability for breach of trust, which is it's the provision before the remedies that didn't make it into the bundle, but it only identifies the trustee as a person liable for breach of trust. In other words, a true trustee, someone appointed in accordance with the provisions of the trust law, and it doesn't contain any mention of third parties, which is the constructive trustee theory of dishonest assistance and knowing receipt. So similarly, Article 59, the remedies provision, it contains no reference to third parties. The claimants seek to fasten on to Article 59I, which states the court may subject to Article 67, invalidate an act to the, or sorry, subject to Article 67, invalidate an act of the trustee, impose a lien or a constructive trust on the trust property, or trace trust property with wrongfully disposed of and recover the property or its proceeds. So the claimant's argument is that constructive or tracing trust property into the hands shows the DIFC law, it contemplates third parties, but that is not correct. Constructive trusts are not only awarded in relation to third-party claims, such as knowing receipt and knowing dishonest assistance, but they most commonly, most of the common remedies against a trustee themselves involve tracing procedures used to identify that property itself. It really is the gravamen of these sorts of claims. So we would say that Article 11 of the trust law only supports using the common law of trusts and the principles of equity to fill out or add to the claims already in the DIFC trust law in a manner consistent with the trust law, including these definitions. And if recourse is had to Section 11 to introduce new substantive claims into the DIFC law, this would be inconsistent with the legislative choice to only include certain claims within the trust law 2005. I found it interesting that in the conversation between the court and claimant's counsel, the court posed the question that if duties are irreconcilable, is there a duty to resign? Which of course, we wouldn't say that Mr. Sassoon's duties were irreconcilable as between BSA and his employer, but that is in fact what he did. And so if resignation is the remedy for irreconcilable roles, then one would have to infer that Mr. Sassoon acted entirely appropriately in those circumstances. Mr. Shivji went on to explain that the problem with irreconcilable roles comes when people act as directors in two entities at the same time. Now, that is absolutely not what happened here. Nobody was ever a director of both institutions at the same time. So we do understand that in the quartermaster case that Mr. Shivji took the court to the directors did act on behalf of both companies at the same time, and want to make sure with my colleague that I have that factually accurate. So that is factually distinguishable from the case here. And so we say that that case does not support the proposition that they're citing it for. Now, we cited to a case called Howard, which we believe is responsive to their point on Regal Hastings, and the hearing bundle site for that is 5547. So it explained that the Regal Hastings decision is explained by the fact that the maturing business opportunity came through the company, but the directors don't have to give a company any opportunity that they come across themselves. So again, we think that it gets to a slightly different point than the claimants are trying to make out in their particulars of claim here. But it also doesn't solve the problem that the claimant's case seeks to say that the directors had used their position or should have used their position at BJSS for BSA's benefit, and that they had an affirmative duty to act in order to do so. Just briefly, in terms of the financial information that Mr. Shivji directed the court to, we would note that on the 2012 financial information, where he says it was still quite significantly profitable, that in and of itself was prior to the change in credit policy, or perhaps at the very beginning of it, at the end of that year. And so the $8 million that he refers to in 2011 reflects the profitability of an entirely different business model. And it is on the record, of course, perhaps not in this bundle, but that the prior model ended up costing the fourth defendant a lot of money because of the risk that they were exposed to on account of it. Just turning to the point on transaction in fraud of creditors. There's a case called Safeway, and we find this at page 7985 of the bundle. And if we go to paragraph 16, Romanet 2. But this is just representative of what we would say the statute requires in terms of a transaction. Here it's tangible things such as customer lists, leases, and debts. And the case that is being attempted to be made out on these particulars is just far more ephemeral than what we see in the cases. So just in very brief summary, the motive that the claimants say they pleaded in paragraph 157 that they took the court to, we would say is particularly circular and is demonstrative of the overall problems that we see with these particulars of claim. We recognize that the court gave us a great amount of time to speak to them yesterday. We're very grateful for the court's indulgence on that. We weren't attempting to belabor points that we didn't think were good points, but I'll just quote Mr. Shivji in one of the first things he said yesterday when he addressed the court, where he described our pleading as sort of weaving together various points, and that weaving together demonstrates the problem. And we would say that actually that problem is wholly derivative of the style in which the particulars are pleaded, that it weaves together a bunch of points and gives this sort of menus-based pleading style that makes it very difficult to tackle these issues in a surgical manner. We attempted to do so to the extent possible, but we would, other than these points, we would rely on our argument yesterday and on our skeleton to rebut the additional points that Mr. Shivji made today.
Thank you very much. Mr. Shivji, is there anything you want to say about any of the new authorities?
I tried to follow. This is a new argument, regrettably. So I tried to follow as best I can and just find the English statute online. As I understand it, what my learned friend's trying to do is re-argue the point that you decided yesterday, or indicated yesterday, about whether or not there are causes of action under DIFC law in dishonest assistance and knowing receipt. This isn't a point that they've actually pleaded these causes of action. They didn't say in their pleading that these are not claims known to DIFC law. But when they took you to the definition of I think their point was that if you look at the definition of trustee, it's quite limited. But my learned friend didn't show you the definition of trust. So
yeah, well, I saw that.
Oh, did you see that? Fine. Okay, so that, I mean, that gets you to the same destination. The concept of trust is drafted broadly in a way that a common lawyer would understand, or an equitable lawyer would understand to be a trust that is perfectly capable of capturing concepts such as dishonest assistance and knowing receipt. And so we say that those accessory liability claims are in for all the reasons I argued yesterday. So for this new point about an unpleaded argument in relation to something your lordship's already heard argument and given an indication on, we say that it doesn't take the court any further.
All right. Nothing else you want to say about any of the other authorities?
No. I mean, I'll say only that we looked at the Safe Depot case. I think my learned friend called it Safeway, but it's the Safe Depot case, yeah. And that was a transfer of business. So the reason my learned friend said it didn't support the proposition I think I relied on, but it does, because the complaint, that was a Section 238 transaction undervalue claim. And the transaction was the transferring away of the business. The fact that the business had constituent elements that are different to this case is neither here nor there. The point is that was capable of being a transaction for the purposes of the section. So she hasn't said anything that undermines my submission. But I've got nothing else to say about the rest of it, my lord.
Right. All right. Well, I'll give you my reasons in writing subsequently, but I'm clear in my own mind that the defendant's applications both fail, and in my judgment, they were misconceived in the first place. They're plainly issues of fact that have to be dealt with. That pleading, to my mind, is sufficiently clear in the essence of what is said. And the defendants have no difficulty and have had no difficulty in pleading to it. It's quite plain what this case is about. And whilst there may be doubt about particular causes of action, the overall scheme of what's done and the conspiracy involved appears plainly from the pleadings and from the evidence that's been adduced. I can see no basis upon which there is any plain and obvious point of law which ought to be decided now, which would justify a strikeout, and the factual issues are such that there can be no question of dealing with this claim on a summary basis. I will set out my reasons in writing so that they'll all be there for you, which you should get as soon, essentially, as I can draft them and the court can process them, which is likely to be early next week. So the question then is deciding what to do next in the case. There are the two issues of security for costs and the change of liquidator to deal with, and also the question of case management directions for the future. Now, what's the most convenient way of dealing with those issues?
My lord, can I suggest that that high on the agenda should be trying to pick a window for the trial date, because so much will be dictated by that. I understand that there will need to be a discussion about what happens to the liquidator, but it seems to me that needs to that is better premised in what is best for the case, because our position for the estate is that it's in the estate's best interest for this litigation to continue on the usual course.
Yes, well, I did make some inquiries yesterday as to what the position was with the courts, as well as looking at my own position. But although it may not be straightforward to decide how long the trial would be in this case, what is the current best estimate?
Our best estimate is 3 weeks, my lord.
Right. Miss Martin, do you have a view about likely duration of trial?
Your Honor, we have no visibility on the number of witnesses that the claimants intend to put forward or how long they'll be on the stand. So it would be difficult for me to handicap that.
Are you able to, in a case of this kind, disclosure is obviously going to be of critical importance, and working out what witnesses are going to be called will depend in part on that. There are 3 individual defendants. Of course, it's a matter for you whether you decide you want to call them or not. There will undoubtedly be an expert from each side in relation to valuation of the business, and one rather suspects there may be some other expertise involved too, but I haven't thought much about that. It certainly isn't going to last more than 3 weeks, is it, Ms. Martin?
3 weeks sounds like a reasonable number to me.
Yes, I mean, I appreciate we're all guessing. But obviously, as soon as you're looking at 3 weeks, the date that can be accommodated is going to be somewhere in the future. I'm told by the courts they're not fixing trials for 2 weeks at any time before next year in any event. I had asked them about a 2-week trial without knowing quite what you would say about duration. But I'm afraid, however one looks at it, we are looking in the middle distance, which gives time to sort out any issues on disclosure that may arise because of Swiss banking laws and all the rest of it.
Yeah, so Michael, from our perspective, we think 2025 is acceptable. I said to you in our skeleton that we could do it faster, but the time will be used wisely, because, as you say, the next stage is disclosure. That is important in a case of this nature, and it needs to be done once and done right. And if it's not done right, it will have to be done multiple times. So it makes sense for that to happen next. I mean, we've looked at our diaries for 2025. I think your lordship mentioned yesterday that your lordship was really looking at the midpoint or latter 2025. And for our part, we also have commitments in the early part of 2025. So the second half of 2025 would be better, because we both have my junior and I both have trial commitments in the early part of 2025.
Yeah. Yeah, well, I'm struggling to find 3 weeks.
And is that even even if we were looking at an October start date, my lord?
October is completely booked. Of course, life changes, as you well know. These are arbitrations which may disappear, but at this stage, I have no way of knowing.
No, I understand. I mean, from our perspective, and we think from all the parties' perspective, it is. I mean, really, a case like this needs to be set down for a trial window now, because then everyone needs to work towards this. And we understand. I mean, we will have to just take whatever gap there is in your diary, whenever that is, and then work back from that. And we understand that your diary, things might free up in the meantime, but that's just life, unfortunately. And I think if we don't, our sense is if we don't set down a date, then this will all linger on. And also, as regards to defendants, we're hoping that now that this case is on an even keel and heading to trial, they will be discouraged from making unconventional applications that would disrupt the timetable.
Well, the short answer is that I can fit a 2-week trial in.
I mean, that is also possible from our perspective. I mean, there is an element of sticking one's finger in the air, but we all know, and one's seen it many times in arbitration, that if the parties are told that they have to fit within a particular time period, so long as it is realistic, then it's achievable. So I mean, it's a different matter, but I've just finished a trial on something colossal where the judge said he's only got 2 weeks and we just had to get it done, and it was done.
Yes, one suspicion is that the evidence, the factual evidence on this, will in the end be limited in terms of witnesses, and that much of this will be argued on documents. That's not uncommon in a fraud trial. So my inclination would be to take a stab at this and fix a 2-week trial date. And if it becomes clear as we're going on that that's never going to be enough, it simply can't be shoehorned into it, then we'll have to think again, and another judge will have to be found, or some other solution advanced. But what I think I'm going to suggest is that we book the weeks of the 27th of October and the 3rd of November. I think that's the best I can do, or the only other option would be to go to December, where I may have another 2 weeks. Oh, well, yes, I could do the 8th of December. I suppose actually, yes, not just through to the 19th, but with a couple of extra days running up to Christmas, 22nd, 23rd. Do the parties have any preference for either of those?
Could I just take instructions, please?
Yes, I mean, it's presumably lawyers' availability that is the more likely problem than client issues.
True, although
Yeah.
it's a very multi-denominational sort of set of people on our side, and I just want to make sure that we're being sensitive to the various religious holidays that I know fall in the autumn time.
Yes.
Yes, and obviously my learned friend will need to inquire about the availability of our individual clients, because the witness availability will matter as well, although with some time out. So one would hope that they've got no plans that wouldn't mean, it would mean that they were unavailable for a day or so when required.
If I could just, I'm going to go on mute for a minute and see if I can get additional information.
My lord, may I do the same thing?
Yes, I think on reflection, it would be better to go for the 8th to the 23rd, which would give us a couple of extra days if necessary. And supposing we get through whatever evidence there is in 2 weeks, that will then give you a weekend and the possibility of putting together closing speeches and so on for the 22nd and 23rd. But having the extra 2 days might be helpful. Then everybody would be flying back to wherever they're flying back to, just in time for Christmas, I guess, if that is a festival being observed.
Well, I would note that I think that probably takes up the entire Hanukkah period, which is problematic for my clients. Yeah. And let me just check on that.
Yes, I
sense that that's the case.
I don't know when Hanukkah is next year.
Okay. So if I could just have a couple of minutes to
sure,
communicate.
Sure.
Thank you.
Usually it's the beginning of December, isn't it?
Yes, according to Google, it's the 14th of December to the 22nd for 2025.
Oh, right. Okay.
So I am advised that my clients are available on the October and November dates that were suggested, but that Hanukkah does start on the 14th of December and go through, I think, the 22nd. So that would be a difficult time for them.
I'm told that the October dates are fine for us, so we would be happy with that. And I mean, my lord, there is an advantage in your lordship having spent enough time with this matter, which means that hopefully there will be some saving at trial as well. And we all just have to be efficient and sensible, as you would expect the parties to be.
Yes. All right. Well, let's work on the basis then of the 27th of October for 2 weeks. Yeah.
I'm grateful for that, my lord. And what we've attached to our skeleton argument, there was a draft order, and what we envisaged was that the court would set down the trial window, as your lordship has, and also direct that we have a disclosure hearing. And I say disclosure rather than document production, because what we will be asking for will look more like some form of English disclosure, which the court has to order.
Give you my provisional view right now. As soon as you're into a fraud case, I think what used to be referred to as standard disclosure, that doesn't mean every single document, but what it does mean is that parties are obliged to produce documents which either advance the other side's case or undermine their own. In a fraud case, it becomes of critical importance that takes place, and I don't regard the usual request for documents as being satisfactory, because one never knows exactly what to ask for in the context of allegations of fraud of this kind. But what I would expect in any case of this kind is that the parties would liaise over the types of document that they would expect the other side to produce. And I have no doubt we'll have to have a hearing in order to determine what the ambit of disclosure should be and how this works in the context of Swiss secrecy laws and so on and so forth. So far as pleadings are concerned, were you thinking of putting in a reply, Mr. Shivji, or not?
Oh no, we did actually, my lord. It's not.
Oh, you have
featured.
You have put in a reply.
We have put in a reply because it was something you ordered. I don't. There's been such a catalogue of points. You may not remember this particular one, but you ordered us to do so. There was actually an argument about the great importance of it on the defendant's side. And so we were ordered to do it, and we did it, and then they didn't even put it in the bundle, and they haven't mentioned it in the skeleton. But anyway, we've done it, so it's there. So I don't
think I've even seen it.
I think it went into an update. It wasn't in their original bundle, and actually we wanted to refer to it on the limitation point. So it is in. It's been stuck in slightly out of sequence, but it is in there. Right. But anyway,
the answer is there is a reply.
Stop. There is a reply.
So pleadings are now closed in that sense.
Right. That's right.
So we are straight on to then the next question, disclosure.
Exactly. Sorry, my lord, can I just mention one point? So your lordship's observations on disclosure we obviously endorse. That we thought it was helpful in order to advance this sort of disclosure to do what the English court does, which is the parties would fill out an electronic disclosure questionnaire to say what they've got. And your lordship probably knows that the commercial court under the new disclosure pilot scheme puts the parties under a huge amount of pressure to actually take their litigators' hats off, have phone calls, cross-party phone calls to try and agree all of this, be sensible, open about what they've got, sensible about where things are likely to lie, to really minimise what comes to the court. So I don't underestimate the effort that the solicitors will have to deploy in order to make that work. But really, this ought not to be the sort of case where every single point where they refuse to tell us what systems that they've got or where repositories are or what document retention they've got. None of that's going to work. and we ought not to be litigating those sorts of points. They ought to do it in the way the commercial court expects. And then if there are real points about the scopes of searches or particular keyword terms, and they really can't be resolved, then we can come back. But I think our submission is that there needs to be a high degree of cooperation and sensibility about this. Otherwise, it will be much more painful than it needs to be.
Well, it's absolutely clear that in a case of this kind, the need for cooperation is paramount. In parties being open about the types of documents they've got and the types of document that they would expect to be disclosed. In terms of what the DIFC rules provide, I'm just looking at part 28 to see what the specific options are. So 2810 deals with cooperation.
That's right. Could I show you?
Yeah, go on.
Can I show your lordship just what we've actually, we think, found a way through on this? If your lordship looks at our draft order at page 2020 of the bundle.
Was it attached to your skeleton?
It was, yes, my lord.
Yeah, let me just find. I will have printed that off, I suspect, then. Yes.
So just ignore the dates for a moment, because the dates are compressed there because we thought we might be doing a 2024 trial. But in terms of the substance of it, we thought the first stage, under the rule that you've just identified, 2810, is for the parties to produce electronic disclosure questionnaires, and we've defined the particular questionnaire that applies, and to do the same thing for hard copy documents, to say what repositories they have. Although certainly for the defendants, my experience of acting for large financial institutions is that the amount that they keep in hard copy now is very limited, and nearly everything will be scanned. So that really ought not to be onerous, but effectively an obligation to tell us in accordance with the English rules what they have. That will then act as the premise for the parties' discussions. And my suggestion would be to actually build in then some real time between that discussion. But actually, parties should also file case management information sheets, and then there should be a sensible discussion after that. The court, we're very happy for the court to mandate a call for solicitors. I mean, I had that recently from the commercial court, where the court required the solicitors to have a joint disclosure call with notes taken of it, so that the court can actually see that the parties are cooperating and being sensible. And then if we have to come back before your lordship because someone's not telling us something or they're being silly, then it's all there for everyone to see what was said by the solicitors in those discussions.
Yes. Ms. Martin?
I note that Mr. Shuji has said that we can ignore the dates for now, and I appreciate that. I guess I would just put in two notes on that. That one, if we can all take into account that next week is Passover, and so I won't have any client access during next week. And I need to be in the US in any event. And so if we can just, as Mr. Shivji says, large financial institutions probably have large, complex record keeping systems. I particularly know that's the case here, where many of the records would be located on legacy systems that are not sort of natively online, because they've been replaced in the meantime. And so I would appreciate to have real time to complete this exercise. We don't have any objection to the exercise.
Yeah, no. I'm well aware of both Pesach and also the time that this will take. And obviously, when one's looking for dated material, that presents problems all of its own in terms of what systems exist. I understand all of that. And if we're not looking at a trial until late 2025, there need be no rush about this. And indeed, time spent now will be time well spent, and save, hopefully, problems arising at a later stage. So do you want to suggest some dates, Miss Martin?
If I could make one other suggestion, and this may be premature, I don't have instructions on this point, but I took the court's comments yesterday about the potential value of any damages resulting from an order in this case, that there may not be very much there. We heard encouragement, one might say, to for potentially the parties to re-engage in settlement negotiations. Now, we think, or my personal opinion is, and without betraying any advice that my clients may have received, that potentially a new liquidator coming online just as an objective matter presents a good opportunity for that. So if the court was minded that the reason that it made those comments was to encourage such discussions and it wanted to facilitate those, we would suggest that it make sense to build in at least a couple of months for the parties to kind of get their footing on with one another and where they fall on these issues. So with that in mind, we would suggest that the schedule that they asked for be produced maybe sometime in July.
I'm always in favour of the parties talking Turkey and attempting to settle. I'm conscious that there was a year set aside tolling agreement in order that the parties could reach settlement, and they obviously didn't. The comments I made yesterday were probably ill-advised in relation to what may be the size of the claim at the end of the day, and were based simply on the limited information that I had, as I've already expressed. But I'm always open to encouragement of settlement and to providing a period for mediation if that's what's required, or whatever is thought to be the best way of reaching a settlement of one kind or another. I never think there's much point in the court ordering a mediation unless both parties are willing to attend it. I also think that mediation is now such an expensive exercise that it's often no more beneficial than the parties' lawyers talking to each other. And I have frequently simply made the order that the senior lawyers on both sides are required to set aside a week and to pick up the phone and talk to each other and arrange meetings for the purpose of discussing settlement, because I think that can be equally effective. But you can take a horse to water and you can't make him drink, as they say. So if you want that built into a timetable, any of those sorts of orders or any orders you think are going to be helpful, I'm very happy to do that. We've got enough time for that to be done. And the question which may arise is, because one of the elements in any settlement is parties' views of their own prospects, is what is the best point in the course of litigation for that attempt to settle to take place. Sometimes it's so clear from the pleadings that the parties think they can take a good view of prospects at that stage. Often it's thought that after disclosure is the best point, because at that stage people will have a better view of material they were otherwise unaware of. And sometimes people take the view, well, actually, we need to see what witnesses are going to be produced and what they have to say. And the question is always, to my mind, in setting a timetable, what is the optimum point at which the parties should seek to get their heads together and come to an agreement? I have no settled views about that at all in the present case.
Mono, can I just offer some observations on that? The first is that the year that the parties took under the tolling agreement was one where the defendants already had our draft predictors of claim.
Yes.
So we've you'd identified 3 points. We've had with the first point we've had, and yeah, regrettably we're not much further forward than where we were 2 years ago. That we think that disclosure is an important milestone. As you say, cases like this are heavily dependent on what the documents show. And so I fully understand, and the office holder accepts what the court says about the obligation always to be commercial and sensible in this sort of litigation. And the officer has a duty to do that. So he more than anybody is dispassionate about the pursuit of this case. But we say that the disclosure timetable ought not to be deferred. We have got more time now because of 2025 trial, but I also hear what my learned friend says about letters of request through the Swiss courts. I have particular experience of that and the time that it takes to do that, and I know from past experience that you need to crack on. So I would suggest that certainly the disclosure exercise is commenced as soon as possible. And it may be that the defendants, when they look at their own documents, that causes them to reflect on their position so far. It may also be just the scale and complexity of this litigation and the cost of pursuing it might also lead to them reflecting. None of that really is for now. But my position is we'll always take a sensible position on settlement, but that shouldn't stop this litigation progressing in the meantime in a sensible sequence. If at any point the defendants or the parties think that actually it would be useful for the court process to be halted temporarily, then of course we'll raise that. But in our submission, we're certainly not at that point at the moment, and I would be concerned if we were prejudicing the preparation of trial for something that has already been given a year's worth of oxygen and not got anywhere.
Yeah. Well, it seems to me the right thing to do is to make orders relating to disclosure. And if then the parties want me to make an order that a couple of weeks be set aside for whatever it is following disclosure, but the parties will then be in a position to better evaluate where they stand and cross that bridge when we get there. So I think first question, Ms. Martin, is on the basis that disclosure is now going to take place, beginning, so to speak, as from now, what sort of timetable is realistic? Looking at Mr. Shivji's draft order. The first being the provision of information about documents in control. 6th May is obviously not realistic.
Thank you. Yes, it is not. I mean, we had genuinely thought that July was a good starting point. So that was not intended to delay anything. And I think with the current time in the schedule, that can be built in. My understanding is that if the court chooses to opt for asking for legal assistance from the Swiss authorities, that such a request can be quite broad and broad enough to cover anything that may turn up. We don't need to sort of go through the exercise of identifying documents before the request goes in so that we can run those exercises contemporaneously. So I don't think it needs to delay anything. And just to sort of bottom out our concerns about that, it's not just Swiss bank secrecy that comes into play. It is actually a violation of the criminal law for them to provide evidence. And so there are two options here. If the client does have the ability to apply to the Swiss authorities for an exemption from this prohibition, it is our understanding that those exemptions are very, very rarely granted in circumstances where mutual legal assistance is available, and that the authorities would consider mutual legal assistance to be available vis-a-vis the UAE. And the mutual legal assistance provides the additional benefit that it provides an exemption both from bank secrecy and from data protection, in addition to the criminal route. And so we would say that it's preferable to go that route rather than just asking for the exemption from the authorities, because that actually doesn't exempt Swiss bank secrecy. So I would just add all that for consideration, that I don't think that need delay the process, according to my understanding.
Right. Well, I don't know much about how that works. I've got some experience of Switzerland, but not a lot. I'm wondering the extent to which I can leave it to the parties to talk and come back with an agreed order, and the extent to which that will simply result in delay and further argument, which will mean coming back to the court in any event. I want to get things moving, but I also want to ensure that we're covering the ground appropriately in the light of what really has to be done. What is the exact nature of the application that you think needs to be made, Miss Martin, because I can make an order that you embark on that within
Could we
whatever an
come back to-
appropriate time scale is.
Could I just get additional clarity from Swiss counsel, then we can come back to the registry with the description of the application that needs to be made for the court's order?
Yes, as long as I'm just concerned that we will flounder with delay and disagreement. So it helps to get as much actually ordered today as is practicable.
Well, as I understand the process, it is for the court through a letters rogatory to request permission for, and then it needs to give a scope, and the scope can be very broad. But if I can just get, well, perhaps I can see if the client can contact Swiss counsel right now and see if we can get something before the end of the hearing.
All right. Okay, what I'm trying to do, Miss Martin, as you realise, is to set some sort of timetable that gets everything moving in terms of whatever the requirements are for compliance with Swiss regulation, and also moves the disclosure process on.
Of course, we're anxious to as well.
All right. Well, do we just park that whilst those around you take some instructions and find out?
I think that's wise.
My lord, can we? It might. We've been going 2.5 hours. It may be that your lordship thinks it's appropriate to have a short break, and that would allow Miss Martin to get that information.
Yeah. Right.
And I think, I mean, I would be also. We would be quite happy for the court to set a disclosure milestone now as well, if the court wanted to do that. So,
well, I do want to do that. Yes,
it does make sense, and I mean, there's certainly been a sort of breakout of good relations in this latter part of the hearing, but historically we've not really been able to agree anything out of court. So our preference would be to set as much down now as we can.
All right. Well, look, let's take 10 minutes out now. And I can have a cup of coffee, which I'm dying for, and we'll come back, and Miss Martin hopefully will have some clear instructions as to what can and can't be done. So it's now 28 minutes past by my watch. Let's say 22. All right, so it's 12 minutes. Yes, where have we got to?
So I had mixed up my processes, so let me clarify what I had said earlier in terms of the ease with which this can all be done and when it should be done. So the recommendation is to go through the legal assistance channels, because it's just not expected that a direct application for an exemption will assist us much here, but that there does need to be some specificity to the requests, including the categories of documents with some granularity, as well as any witnesses that are sought to be interviewed, and that will need to be done all according to the process, and that should all be done once it is decided what is to be produced. So I think that the order should request us to produce, at least in the first instance, a draft letter for the court's use in a letter rogatory, which we're of course happy to assist the court with.
Okay. Is there anything to stop that process occurring at the same time as what's envisaged by Mr. Shivji's draft order?
Just a matter of identifying the categories of documents.
Yeah.
Just that there's the semi-specificity requirement. It doesn't require you to go document by document, but it does require identification to a certain extent.
Yeah, I'm sorry, I'm not quite understanding at this stage. I'm probably being stupid, but the letters rogatory will relate to the production of the actual documents, but is there anything to stop you at this stage providing information about the repositories of documents and exchanging electronic document questionnaires? In other words, do you know enough about the categories of documents that exist without going the letters rogatory process having been completed?
But I think it's an exercise that we'll want to undertake with some careful attention to it. So we just would ask for more time than is currently built into the schedule. But no, there's absolutely nothing to prevent this. So yeah, we would encourage this process to go forward.
My understanding, my lord, in answer to your question, is that there's no issue there. The issue is simply on the production of the material,
exactly.
On their concern because of the contents of it.
Yeah.
So if anything, carrying out this process helps them as well, because it's a process that leads to identification, and that gives them particularity.
Yes. Well, that was exactly what I had in mind. So the question is, first, realistically, not 6 May for paragraph 1, but what would be a sensible date? And what's a sensible date for you to produce a draft letter to the registry?
So my understanding of what was being suggested was not just that we go through this exercise of identifying the repositories of documents to come up with a letter, but that we go through the subsequent process of.
Sure, but first stage is to identify, what's thought to exist. That's the first thing. So that's paragraph 1.1 and 1.2. That seems to me to be the first port of call, and we can file case management information sheets at about the same time, and you can provide a draft of letters rogatory and so on and so forth at a point that makes sense. But first question then, Ms. Martin, is not 6 May, but when can you produce information about the documents in your control?
Could we request to closer to the end of May, to the 27th of May?
Yeah. Okay. No problem with that, Mr. Shifty.
That's fine, my lord. Thank you.
Yeah. Okay. So that's paragraph 1. Then paragraph 2, file case management information sheets by that stage, and then is the opportunity to identify all the particular issues that arise in relation to letters rogatory and so on and so forth. So it gives you over a month to work out quite what processes need to be done and what the form of documents needs to be. And so I would say 27th of May for case management information sheets and drafts of what is required to get letters rogatory issued and so on and so forth. Does that make sense, Ms. Martin?
It does make sense. I'm not sure that we'll have enough information at the point for the draft to be
fine. It's to know,
practical for the court's purposes, but we're happy to
it's
produce.
A start.
Yes.
It's a start. I mean, I'm sure we won't be able to finalize it at that point, but at least, it's getting things moving, which is the key, I think. And then when do we want then to have a case management conference that makes sense to see how things are progressing? This is working on the basis that the parties are cooperating and working together to try and make sense of what can be done. When, Mr. Shipchi, would you visit that?
I would perhaps suggest late. Sorry, let me just have a look at the diary. Probably sometime in mid-June. That gives the parties then more than a couple of weeks to talk about what they've got. I mean, there does need to be some industry by the parties once those documents are served to really try and understand what's going on. Fulsome provision of information, cooperation, with a view to trying to agree things, and if not, coming back. I think we should list a hearing because it's inevitable that we will want to be before your lordship, but that shouldn't undermine the need to try and agree as much as we can. So sorry, my client has just said that there is an Eid holiday on the 17th of June.
17th through the balance of the week for the most part.
Well, I was going to suggest looking at my diary, the 10th of June. Does that make sense?
That does. Let me, can I just double check? But I think that works. Yes, that's perfect for my clients.
Does that work for you, Miss Martin?
10th of June is works for us. Things start to get very tricky for us starting the 17th of June for about a month.
Okay. Right. Well, let's put that as 10th June then, and case management bundle would then be a week beforehand or something. 3rd of June, 10th of June, and then we'll see where we go. The case management information sheets, I will want to know, and I appreciate that won't be final, where we've got to in terms of disclosure, what has to be done, what the parties are currently thinking about witnesses and experts and so on and so forth, what sort of experts might be required, and even if we don't reach final conclusions about all that, we'll have a better idea where we're going by that exchange of information. All right.
My lord, can I just ask on that, just picking up on a comment you made earlier, I suggested that we might actually want to put the disclosure milestone, set that as well. Just having reflected on it, in light of what your lordship said about standard disclosure under the English CPR, yeah. we think it would be helpful for you to order that now, but perhaps to say that the date for compliance is then to be determined on the 10th of June, because I think it's helpful for both sides to understand that it's going to be English standard disclosure. That's a concept we all understand. And then we can come back at the 10th of June when we're a bit better informed about the scale of the exercise as to what the sensible deadline should be for that.
Well, I'm perfectly prepared to make it plain that I think this has got to be a case where, we're not talking Peruvian guano disclosure, but we are talking of the sort of disclosure that occurs in arbitrations where the order is made that you must produce all documents upon which you rely and all documents which you can see undermine your case or advance the case of the opponent. That seems to me absolutely fundamental in a fraud case of this kind. So I'm certainly prepared to say that, and the timing, of course, depends upon the volume of documents that exist, and it's no good making orders without Miss Martin knowing what she's got. And I take it you've had some sort of preliminary discussions about this, have you, Miss Martin, with your clients, or not?
We have.
Yes. So
they've certainly attended this particular rodeo before, to use an American phrase.
I'm sure they have. I'm sure they have. Yes. All right. Well, there we are. I'm happy to make that order and put that into this form of order. So if you want to produce a draft, Mr. Shivji, and agree that with Miss Martin, all well and good. That would be the sensible way forward.
I'm grateful.
All right. Now, does that cover that aspect? Yes. And we then move on to questions of security for costs and liquidators meeting and so on and so forth.
Yes. And my preference would be to deal with the liquidator first, because that, I think, it affects the only outstanding item on the security for costs, which is the suggestion that the insurance policy should be assigned. There should be an order requiring the liquidator to assign the policy to the new liquidator. And I think once we have a bit more clarity on that, the handover mechanism, then that will be an easier question to answer.
Right. Well, what has to be done? There's a creditors meeting that is now fixed for, remind me what date?
The 29th, I believe. Sorry, just double check.
But 29th of this month.
I believe so. I'm just sorry.
That's correct.
Yes, 29th. That's right.
Yes, that's right.
Okay. And have the parties been in discussion about the identity of illiquid data. But when I say the parties, I actually mean, of course, Mr. Whaley and so on and so forth. The people who are going to be creditors here, have they been in contact at all?
The only contact that we've had is the correspondence that we received, letting us know about the application that was made by the Al-Kharafis and the creditors meeting that was called by the current liquidator. So there hasn't been any other. We asked them to agree a mechanism, and they basically just said, "You already have what we intend to do," as if it's a something, a conclusion that's already been come to on the part of the current liquidator and the Al-Kharafis, that this is how it's going to go forward.
I'm sorry. Has someone even suggested the identity of a replacement liquidator?
So my lord, on that, we've done what we are required to do in the rules. So we were asked to schedule a meeting for creditors. We have summoned that meeting, and we under our notice of meeting, we have given all the creditors an opportunity until the 24th of April to nominate their candidate. So that date hasn't yet come. They will have to all nominate their candidates, and then there will be a meeting of creditors to vote.
Nomination date was 24th of April, did you say?
That's right. That's correct.
Okay.
So it hasn't yet hit, and I don't. I mean, I'm acting for the estate, obviously not
sure.
any particular creditors. So I wouldn't expect us to be involved in whatever discussions might have between particular creditors as to what they might want. But so I can't really inform your lordship an answer to those questions. And it also seemed to us that I mean, it's important to have a firm eye on who is here today. It is only the estate and one creditor, and
yes.
and the only issue that we understand is
two creditors.
Two creditors. Okay. The only issue that we really understand that needs to be grappled with today is essentially your lordship's previous order about the current office holders point at which he remits office, because our position is that there obviously needs to be continuity. I mean, we're not even sure how the estate could function without continuity.
But the obvious answer is that the date of his resignation, removal, should coincide with the date of the appointment of the new liquidator.
Yes, that's exactly what I was. That's what exactly.
I don't see any point in messing about with provisional liquidator or anything else. You might just, well, let's be sensible about this. Yes. Miss Martin, this may be a silly question to ask, really, but are your clients in touch with the Kharafis in relation to the identity of a liquidator with a view to seeking some sort of agreement?
We haven't been. I've been in touch with Pinsent Masons in the past, and I'm happy to make that phone call. The thing that we think is required in advance of that, though, is we really do believe that a statement of affairs is required so that we can approach potential replacement liquidators and they can commit to having no conflict to act and being willing to act.
Well, I understand that, but I mean, there's nothing in the estate, is there, really, except for this claim, and the Al-Kharafis are funding it, so that I can't quite see what the problem is in the both your clients and the Kharafis seeking to agree the identity of a liquidator, and the statement of affairs will come forward at the creditors' meeting, and you can see what the position is. But you don't need that information in order to nominate a liquidator, do you?
Well, in the proxy form that they sent through in the nomination form, there was a space there that said that you needed to confirm their willingness to act.
Right.
And I don't know anyone who wants to act in a situation like this if they're not going to get paid at all, if that's not essential.
But that is, I mean, sorry to interject, my lord, on that. But there must be a sort of degree of reality about all this. This is an insolvent estate. As matters stand, it has no capital within the state, and the fees incurred exceed. Well, it's full of fees from this litigation and the work that's being done, rather than any funds to fund. So an insolvency practitioner will be very familiar with that. because that is often the nature of the beast. So just speaking from the estate's perspective, we don't accept my learned friend's submission that there is some obstacle to appointing a new liquidator. And I mean, on beyond that, I don't need to offer any observations. I mean, the interest of the estate is that there should be a smooth handover from one office holder to the next, and also critically that this litigation ought not to be derailed. And we know in our submission the reason why the defendants have invested all this money in changing office holders, and that is the hope that it would somehow give them a commercial benefit in this litigation. But that isn't going to work, because it is being decided it's in the best interest of the estate to bring this claim, and an office holder will have to take over this claim, seeing what the court has said today about the merits and seeing essentially the state of the advice. So there ought to be continuity for the estate. It doesn't prejudice what your lordship said earlier about settlement, but there isn't going to be some great advantage to the defendants in this, and it would be helpful from the estate's perspective if they rather just let the process happen, because the sooner we have a new office holder, the sooner we can just get on with the work that we're all doing.
Yes, well, if this matter's coming back before me on the 10th of June, then I can make it plain that in the event of no agreement, I will appoint a new liquidator at that point. That provides a terminus ad quem. I'd much rather it was all sorted out in advance, which is why I was exploring the question whether there was any possibility of the creditors, I should say, the creditors, speaking to one another to seek to agree on the identity of a liquidator. I mean, I appreciate practitioners may not be queuing up to do the job, but you know, this is not an uncommon situation, is it?
It's not. We actually appreciate the court suggestion in that regard, and we did in fact write a letter to Pinsent Mason saying that we think that the thing that the creditors should do, the two most significant creditors, is attempt to agree. So that is in the bundle at 8355. We didn't hear back from them on that letter, so that is absolutely in line with our thinking.
Okay, well, can you press them to do that? You can speak to Pinsent Masons and see what they have to say about it and whether they're prepared to play ball. As I say, I can't really think that you need to see a statement of affairs before you identify someone. And as I say, it's pretty obvious what the position is in very broad terms in any event. So there we go. Creditors' meeting is obviously the first opportunity where the parties, where agreement to a new liquidator could be arrived at. But if it isn't, and the parties wish to then put before the court their own nomination, I will make a decision on the 10th of June. Or if necessary, if it's really urgent, I could do it on paper before then, I suppose.
Yeah, I mean, my lord, on that point, in order to minimise the we obviously take what your lordship says in the removal judgment, but in order to smooth the transition, we say it does make sense for this brief period for Mr. Hayder to remain in office until a new appointment is put forward. There is a process under the insolvency law for appointing liquidators, and that is the process that is being followed. So the meeting has been summoned. The creditors have an opportunity to put forward their own candidates, and then they vote. Yes. I'm not offering any observation on it at the moment, but there.
Can't hear you, Mr. Shipji.
I'm so sorry, my lord. If the defendant's hope is that they will find their own candidate who they're proposing to fund, who will then discontinue the litigation on appointment, that, I mean, there are serious problems with that.
And of course.
And it will be a matter that there will be a question at the meeting about the propriety of all of that, and I don't intend to express a view about that now. I haven't considered it in detail, but it will be a matter for the person chairing the meeting to consider conflicts of interest and the propriety of the meeting. So that is a world in which there could be an almighty spat at the meeting. But I'm not trying to incentivize the defendants to do that, and they shouldn't think that if they do that, they'll somehow be able to come back before you and then be able to put a list of candidates before you, and you'll be able to choose one, because that's not how this works. This is ultimately a question of majority rule, and it's a matter for the creditors' meeting in the first instance to decide on that in accordance with the process under the law. So we'll see how that meeting goes. But I just wanted to raise that.
I'm not going to interfere with the ordinary processes unless an impasse arises where the court has to take action. As I say, one would hope that the creditors would be able to reach agreement. But
could I just ask two questions in that regard? Because we had written to the liquidator through his solicitors to ask which specific provision they intended to follow, and we did cite Article 90 of the DIFC insolvency law, and I don't recall in their response that they actually specifically responded to which process they intended to follow, if that was the one. We also asked a question about the voting mechanism in the regulations, specifically chapter 6.13. So if we could just get confirmation that that is in fact the process that they intend to follow, that would be helpful. And just, this is a very personal scheduling request. Is there any way we could just push the creditors meeting by a day, only because it's causing me to have to change an international flight and miss some important family affairs that I had really hoped to attend? Mr. Shivji, I believe you're on mute again.
You're muted again.
I'm so sorry, Margaret. So on the latter point, that I'm afraid to, I'm so sorry for my learned friend's personal circumstances, but I mean, this is a meeting that is summoned on 21 days' notice in accordance with the law. It's not possible to move. I mean, it's certainly not possible to shift the date of a meeting like this. It's a notice to all creditors. They need to have the appropriate notice unless the court curtails it. So I'm afraid I can't see at the moment how the meeting just could be moved by a day. And in any event, I don't have any instructions on any of this. So I'm hoping that my client agrees with what I'm saying. And then the second question is, my learned friend has asked about the provisions under which the meeting is summoned. I think she was right. It's 613. Yes. So in the insolvency regulations, under the heading provisions applicable to compulsory winding up, there is a provision 6.13, specific provisions regarding creditors' meetings in a liquidation, and then it sets out the procedure for the appointment of a liquidator. So so that's where we are, and I don't think that's in the bundle, I'm afraid.
Right. Well, I don't think.
If I could just apologize.
Go on, Ms. Martin.
If I could just ask that if the court is intending to make an order in that regard, that it also just reference Article 90 of the insolvency law, because it does make a specific provision for if there's no agreement that the parties can come back to the court. Now, the court has already anticipated that we can address it at the 10 June hearing, and we're grateful for that. But we just ask that be part of any order.
I think I'm so sorry. I know this back and forth is not helpful, but I think my learned friend might be wrong on that, because I think Article 90 deals with something different. I think Article 90 deals, I don't even know if Article 90 is in the bundle, but it deals with, I think, the first appointment of a liquidator after a winding up order. So that may not. Are
we talking about the regulations?
No, I think now my learned friend's talking about the insolvency law.
And I agree with that. This was part of our question that we posed, as we said it's not directly applicable, but are we just envisioning a sort of modified version of it? Because the provision
I'm so sorry. I don't mean to come across my learned friend, but I think one needs to be very careful about the court being asked in this way to try and make orders under the Act, which there's no application, there's been no argument. His lordship has obviously made observations about what will happen if things can't be resolved at a creditors' meeting. But I'm not, as on behalf of the estate, I'm not asking the court to make any order today about any conduct of the meeting or any process. The only thing that I needed to cover off was the continuity which your lordship has addressed.
Yeah, well, I think that's what the position is. I think I've indicated what I hope will happen. I've indicated that I will determine any applications which are made on the 10th of June in relation to the new liquidator and his identity. And I'm certainly going to order that, insofar as it's a variation of what I've already ordered, the current liquidator is removed only when the new liquidator is appointed. And I think that's all I can do at this stage, isn't it?
Yes, that's exactly, that is in my submission all that the court's being asked to do.
Very good. And I think, as I say, I've made it clear what I hope is going to happen, and you know that well. And I rely on lawyers on both sides to do their best to achieve an amicable result with the Carapis.
It is certainly our intention, and I would notice to Mr. Sheepshe's comments about, and he has a wild imagination, I have to give him credit for it, but that we intended to tee up a liquidator who we were therefore going to fund and conflict out in that way. I mean, it never even crossed our mind. It's well, impressive, but it's highly inaccurate.
It wouldn't succeed. It would be,
of course not.
It wouldn't even come in the categories of that was a good try.
Absolutely not. But I would ask him to stop imputing intentions and actions to us that we have absolutely not even crossed the transient of our imagination.
Right. Well, let's hope suspicions are allayed. All right. Where do we go next then after that?
So I think it was on security for costs, but I hope the piece is broken out on that front, my lord. I think there were 2 points that we canvassed yesterday. One was this point about in the event that the policy is terminated by the insurers, that the defendants ought to be notified, and we accept. Yeah. We're quite happy to give notification. I'm not sure that needs to be in an order.
I'll put it in an order so there's no room for any argument about it.
So that's fine. I'm grateful for that. And then the second point was this question about the court was being asked to order the assignment of the policy from the existing liquidator to the new liquidator. Now, your lordship,
what I'm inclined to do is to give liberty to apply in the event that by whatever a given date there has been no assignment, because that puts the whole thing then up for grabs again. Because if there's no assignment, there's then no security.
Yes.
And it's open then to Miss Martin to say, I want security in another form. So I'm not sure that I can actually order an assignment in any event, but I can give liberty to apply, so she can apply for whatever she wants to do if there's no assignment of it by, and the question is what would be a sensible date to again, is 10th of June a sensible time, or 3rd of June? So the parties come back before the court, deal with it on the 10th if necessary.
What I don't know, and it's a slightly nebulous question, is how long it will mechanically take the insurers to issue the new policy. And there's also this point about, I mean, what we've proposed on the endorsement is that we have a window to get the endorsement issued. Yeah. But that window actually might result in the change in the identity of the liquidator. Yeah. And so we may be able to do both steps in one and just simply get the endorsement issued in the name of the new liquidator, which would solve both problems.
Well, I'll tell you what I'll do. I'll simply give liberty to apply, and on the 10th of June we can see exactly where we've got to.
Okay. Well, I'm grateful for that, and we understand your lordship's point, which is that there needs to be an enforceable policy in place, and if there isn't, then we will be re-arguing issues of of security.
Indeed. All right. Well, that solves that.
So my lord, I think that's. I mean, so the last question is costs, and we say that we ought to have our costs on both applications, and so I say that. I mean, the vast majority of time and effort has been devoted to the strikeout and summary judgment. I mean, that's on a different scale to the work that's been done on the security for costs. And we have, your lordship can see we've laboured pretty hard on this, and the cost that we've incurred. We filed a statement of cost. It's a 2-day hearing, so ordinarily your lordship wouldn't be asked to summarily assess costs for a 2-day hearing, but we would ask for a payment on account, and we filed a cost schedule, which is in the bundle, and our cost schedule is at page 8133.
Well, I'll tell you what my provisional view is about the security of costs issue, and that is that it should simply be costs in the case. Subject to anything Miss Martin says, I've refused her applications on summary judgment and strikeout, so she'll have to pay the costs of that. Those seem to me to be the appropriate orders to make, unless either party wants to make any serious argument against that.
Well, only on the security for costs, Your Honor. Could I just ask Mr. Devonish to address the court? Because we believe that the application could have been entirely prevented if they just provided the policy earlier.
Yes, if Your Honor is happy, I have 5 minutes or so of comments that I'd like to make on the security, the costs of the security for cost application. We think it would be wrong to bundle that together with the strikeout application, which we did lose, but we didn't lose on security for costs.
Yeah, well, I'm not thinking of ordering you to pay the costs of the security for costs. I'm contemplating costs in the case. So the ultimate winner of the action will get the costs of the security for costs application.
Oh, I beg your pardon. I misunderstood you, and I thought.
No.
Okay.
No. It's undoubtedly a separate application. Do you want to argue against that?
I don't.
No. Very good. Thank you. All right. So, Ms. Martin, I take it that you can't really resist the cost application in relation to the strikeout and summary judgment.
Could I just have a moment with was the court prepared to address figures today on the strikeout?
Well, payment on account would seem to be the right thing. Obviously, I'm not going to summarily assess the total, but ordinarily one would be looking, as you know, at a figure of about 50% of whatever it is that's being claimed, which I haven't even looked at yet. But page 8135, I'm told.
Yeah, it's 81. So, my lord, our statement of costs are at 8133, and the final figure is at 8134, and that is in AD. And just by way of sorry, I'll tell you, someone's going to email me the US dollar figure for that. But while I'm just figuring that out, for comparison, my learned
it's about $200,000, is it?
It is. I'll get you the exact figure in a moment, my lord. And my learned, just by way of reference, my learned friend's costs for the same application are $425,000, and your lordship can see that for 8129. So I've got our cost in US dollars $199,000. So which is slightly less than half of my learned friend's costs. So we say that's a pretty good indication that we're in the right zone. I'd in those circumstances I'd ask for more than 50%, but I'm in your lordship's hands.
Ms. Martin?
I'm not minded to resist that, but I just want to take instructions very quickly if I could.
Yeah.
No objection to that approach.
All right. Well, Ms. Martin, I was thinking of ordering 60% on the basis that the figures seem to me to be such that I could be very confident that 60% would be recovered, which would be $120,000, give or take, whatever that is in AED. Do you have any problem with that?
We can accept that.
Very good. Do you want it expressed in dollars or AED, Mr. Shivji?
I believe AED is fine for us.
Well, if someone would like to do the multiplication by 3.67 or whatever it is, $120,000 in dirhams. I'm waiting for someone to do the maths.
Oh, I have it for 440,000 roughly.
Yep, that's fine.
440,000, we'll call it payment on account. And how many days do you want to pay it, Ms. Martin?
We generally need at least sort of 3-4 days to get a payment out the door and make sure it makes it out the door, because there is a process. So
Well, I was going to give you 14 days.
Oh, wonderful. Thank you.
All right, 144,000 AED within 14 days.
No, I think. Sorry, my lord. I think it was 440,000. I think
That's what I said, didn't I?
Oh, so I'm so sorry. It came through. Sorry, it came through differently on my.
No, 440,000 within 14 days. Yes. All right. Now, anything else?
No. Can I just check? Sorry, my lord. Can I just check for a moment? I don't believe there is, but if you just give me 10 seconds just to check, please.
And I'm looking for a draft order, Mr. Shivji, which you will draw up and seek to agree with Ms. Martin, that covers all of the aspects that we've dealt with today.
Of course. No, that's everything on our side. Thank you, my lord.
And Ms. Martin, anything else?
I'm just confirming, but I don't believe we have anything else. Nothing else.
Very good. All right. Well, thank you all very much. As I say, you'll get my reason sometime next week, no doubt. If you wouldn't mind all signing out and again just letting me have a quick word with the associate, that would be very helpful.
Thank you very much.
Thank you so much.